2023, let the cause title be corrected by substituting DP within bracket DP. DB.
Division.
Acha, DB within bracket in the place and stead of our within bracket NDPS. Let this stop, let this correction be incorporated in the order date such and such.
This is correction being incorporated.
In the same order.
Item number 3.
3 with 4.
Lordship, item number 3-4, Lordship, I am mentioning one thing, Lordship. The main matter, Lordship, CRM NDPS 428 of 2023, along with these two matter was tagged. Lordship, that hearing was concluded in 7/7 and
Just to we remember one second.
Case diary is
Case diary.
Yes, it is.
Only for
Lordship.
filing case diary.
Lordship,
Copy
that
of
is not in the list.
This
Only
is in
to say-
Jogaram.
Jogaram.
In Chandra Bahadur. not
Chandrabahadur, Aniruddha বিশ্বাস was appearing. I
Okay.
don't have the case. Malad remembers the original case diary was there. My directed.
Yes, yes. That is why it has been listed
Lordship,
today.
I have handed over.
Congratulations.
Today which will see that. Hearing to think as a
ন্যাচারাল প্রসেস মানে আমাদের অফিসিয়াল হতে যাবে
এটা বড় অর্ডার
কি করবো সিরিটা নিতে সেটা আমার উপর আছে তোরা এই করিস না আমাদের তো কোথায় আছে
পরেরটাও তো অনিরুদ্ধ
Aniruddha বিশ্বাস,
on his way.
he will file the.
Yes, yes, yes.
You will file the CD, no? তাহলে
I
দুটো
had a talk with him.
Hello.
He's bringing this.
দুটো সিডি যাবে বুঝেছো দুটো সিডি কলকাতা যাবে
All right, Ms. Doctor, yes.
Item number 5.
State,
আজকে এটা হবে সবার আসতে
pass over, nothing. State is not there.
Item number 6.
give us some time
স্টেট
on the way
torrential rain is a good ground for passover
this matter that column came only
be that as it may we have to wait for some time.
Item number 7.
Seven, I am for the state, my lord. In this case, my lord, several times bail applications were rejected.
Appear on behalf of the petitioner. Lordship, in item number 7, this is allegation under section 4 and 6 of the POCSO. The petitioner is aged about 40 years and the victim girl is 10 years. There has been a custodial detention till date about 4.5 years. Charge sheet has been submitted. 2 of the CS witnesses out of the 10 CS witnesses have been examined till date. Lordship.
My lord, order CD is not with me, my lord.
It is not.
Several times the bail application has been rejected, not only once. They have written once, but prior to that, several times the.
By this court.
Yes, my lord.
Then that's a misstatement. On that ground alone, we'll dismiss. If they have said only once, they have annexed only one order of rejection.
Several times it has been.
Lordship, I have only been instructed on being. rejected
Madam, we
once.
are not blaming you at all. You are all creatures of instruction, but it is your client
Yes.
who's trying to be smart
Yeah.
by concealing facts from the court. We don't accept that. Suppression of fact is a ground for rejection of anything.
My lord, one is fact that 2019 CS was filed, 2 witnesses examined. Let it be ordered for a speedy disposal. Within 6 months, we'll dispose the matter.
নেক্সট সাইডে চলে যায়
Next step.
Next.
So we are not going to allow this application. Try your luck.
Item number 8.
Your Lordship, I am for the petitioner praying for the Passover.
9. 9.
নেক্সট সাইড
10.
Your Lordship, I am for the petitioner praying for Passover.
11. I am for this.
স্টেট passover
Lordship, CD not produced, Lordship, next circuit, Lordship.
Next, sir. 12.
Yeah.
13. Your lordship may kindly pass over the matter. 14.
I'm for the estate.
CD is there.
Yes.
My lord, this incident was happened on 13 July.
Allegation, sir, allegation.
Arms Act, Arms Act.
Arms Act, my lord. This incident was happened on 13 June 2023. And this suo motu complaint was 14 June 2023.
Political rivalry.
Yes, my lord. This petitioner was arrested on 13 June, my lord, prior to the
Two CD.
initiation of the FIR.
Recovered from him.
Both the cities.
Nothing has been recovered, sir.
Yes, recovered.
Recovered from him.
Yes.
Sir, I am in custody about my lord.
Lordship says-
60 days, my lord.
Lordship says
You are a man of Munge. Huh?
countrymen.
And how do you get
Countrymen,
this?
Lordship.
Our-
Lordship, page 3, inspection cum arrest memo dated 13/6/2023. The incident of 13/3/2023,
60 days I am in custody, my lord.
FIR was lodged on 14/6/2023.
What is the seizure?
Caesar Lordship, page 23.
But prior to the register of the FIR, I was arrested. Kindly see.
Seizure from him.
From him, offering improvised weapon made firearms seized from the house of the petitioner, leading to his recovery. He was taken and it was recovered.
Not at the court, my lord.
And
Not
36,
from your house.
36, 37, 161 of poor villagers who names. There was a mob. Seeing the police came to, at the time of filing of nomination, Lordship, the police came to the spot. Seeing the police, one of the person, not named in FIR, one of the person fired 4 rounds in the air. This case started.
I am not the same. But
The leading statement is recovery statements, page 22. I've given the original as well as the Xerox CD. Both of them.
Ashun. Ashun, man.
Lordship.
Heard learned advocate for the petitioner, learned advocate for the accused at length. It is contended on behalf of the party. It is contended on behalf of the accused petitioner that considering the fact that the present case is the outcome of a political rivalry and wherein the present accused petitioner has been falsely implicated, comma, the instant application for bail may be considered favorable. It is further contended, continuation, it is further contended that the present accused petitioner is languishing in JC since
on 13 June 2023, about 30 days.
date.
13 June
You can-
2023.
While opposing the prayer for bail, learned advocate for the state draws our attention to the seizure list as well as to the statement of the present accused as recorded under section 161, leading to the discovery of the alleged illegal firearms. Stop. Para. On perusal of the entire materials as placed before us, we are convinced that there are sufficient incriminating materials as against the present accused petition. However, full stop, comma, however, considering the period of detention and also considering the fact that investigation has in the meantime progressed substantially, we are inclined to allow the prayer with some stringent condition. It is as ordered that the present accused petitioner may find bail of rupees 10,000 with 2 registers to a like amount, subject to the satisfaction of learned SCGM, Dinhata district, Kuch Bihar, with a further condition that the present accused petitioner shall meet the investigating officer of this case as and when called for till submission in final form, and that the present accused petitioner shall not leave district Kuchbihar till conclusion of investigation.
Grateful, Lordship. আমার দুটো সিডি আছে হ্যাঁ?
Investigation. Accused 160. Till conclusion of investigation in connection with this case.
Grateful, Lordship.
Item number 15.
Lordship, I am for the state. I'm praying for a short Passover, Lordship.
Now, item 16. For the petition.
I put the state.
This is that case where my Aadhaar card has been misused in order to book some parcel which contains gaja money. That case one. I was pleased to ask the state whether TI parade was conducted or not.
Right.
TI parade was conducted.
My lord, there is mere anticipation. He is booked in another case in Patna, my lord. Same offense. Page 89. Page 89.
So how do you explain that position, sir?
But I have not suppressed that. I have mentioned that, my lord. But in that case also, my Aadhaar card was used. Nothing has been recovered from my possession. Same thing, my lord. My lord,
Where you have disclosed your about prior incident?
my lord, page,
Eight.
page 4,
Para
paragraph
8.
8.
No recovery from him. But he has booked
He booked the consignment and same he did it in Patna.
booked the consignment with the RMS,
RMS.
Railway Mail Service.
Yes. Page 10, 11.
The booking slip doesn't
Page
contain my
10,
signature.
11.
I was not physically present there. Only my photocopy of my Aadhaar card has been used.
There is the receipt. Receipt copy.
Is there any CCTV footage also?
Yes, sir. Yes, my lord.
CCTV
Yes,
footage?
my lord. That was in the CD, my lord.
He personally went and booked it.
Yes, my lord.
Where is the CD? Where is that page?
That yellow.
This one? No.
Might be, my lord. There is CCTV
Footage.
footage collected. Yes, my lord.
Whether he is the petitioner or not, that has to be verified.
My lord, kindly peruse.
Someone has booked it, otherwise how it can be, but that is not the petitioner.
The world has got into the habit of using your Aadhaar card to send ganja.
How is it possible, my lord? Patna, West Bengal.
Even for applying for a SIM, for a railway ticket, Aadhaar card is obtained.
He was booked.
But anyone can misuse that.
No, where is the CCTV footage?
My lord, may I? Memo,
Memo of evidence you can show also.
Shall we pass it over?
my lord, short person.
We want that his presence can be secured in the CCTV footage or not, that is why I want.
I know there.
Find it out.
Because
17.
May it please, my lords. My lords, I beg to appear in item 17, my lords, for the petitioner. My lords, my learned colleague will be passing a judgment, my lords, in this case, my lords, in terms of section 52A of the NDPS Act, my lord.
Passover, it is Passover.
Passed over, passed over.
Item 18. And for the petitioner, Lordship. Lordship, non-compliance of 41B, Lordship.
How?
Non-compliance of, as I said, column 10 is.
Blank, blank, blank. Here,
Same হবে ওই সেই লিঙ্কের item 33 মতো।
33 sheets.
Yeah, have you annexed the address memo?
Yes.
Page number, sir?
খালি তন্ময়
18.
লেখা আছে দেখবে অর্ডার গুলো কলম 10 is not signed by an independent person again সেটা না করে not signed by এটা একেবারে সেকশন থেকে তুলে দিই not signed by a member of the family or respectable person in the locality. A member of the family or a respectable person in the locality. 41 B type চোখ বুলিয়ে নিও locality. 41 capital B type চোখ বুলিয়ে নিও CRPC.
আমার অর্ডার আছে তো সব।
বেশিরভাগ ওটা ইন্ডিপেন্ডেন্ট পারসন স্ট্রিক্টলি স্পিকিং দ্যাট ইউ কে ইনভেস্ট ব্যাপার করে
ওইটাকে রেফার করো।
সন্দেহ হলে আমার কাছে দেখিয়ে দিন ভেরি গুড কত হলো এটা ওখানে ওরম হয়ে যাচ্ছে কেন
Item 19.
Have you got it? Okay.
Item 19. And then Lordship, non-compliance 41B, Lordship. Page number 20, Lordship.
Page number 20.
There is no column 10 Lordship in the format. So where do you take the signature? New format.
New format.
What it seems, Lordship, is not the one which we are accustomed to seeing.
No, it is here. 8-2. Name and address of the witness in whose presence the arrest was made.
None was present, and it is mentioned in the complaint also. No witness was present. They approached the shop owners and passerbys, but they refused. It is mentioned in the complaint.
None was present.
Lordship sees the volume, what they have done. But the question is, Lordship, under section 100, at the time when the witnesses are approached, if the witness refuse, proceeding has to be drawn against them.
That has been done.
No,
Not that has been.
they have asked, they have refused, but no proceeding to that effect.
এখানে কালাম নাম্বার 10 এর জায়গায় 8
কলমটাই নেই।
Roman 2 হবে। সবই একই।
Lordship, the original case diary.
একবার দাও তো।
ওইভাবে আমাদের কি নম্বর মনে আছে ভাই
নম্বর যেরকম ওই যে কালাম নাম্বার 8
FIR page 3, Lordship, local witnesses refused. In fact, in the Caesar list also, the police personnel are the witnesses who signed, because local witnesses refused.
Page number 3, which portion?
Lordship, on the top,
but they refuse to stand in the
Lordship, Lordship.
ঠিক আছে তাহলে ওটা হবে 8 Roman 2
Lordship. Lordship, section 100, subsection 8. Any person who without reasonable cause refuses or neglects to attend and witness a search under this section when called upon to do so, an order in writing delivered to tendered to him shall be deemed to have committed an offense under 187 of the Code of Indian Penal Code.
No, so then academic question, Mr. Ganguly, what happens if really no independent witness
Lordship,
can be found, then it can't be arrested?
Lordship. But here the case is that they were approached, but they denied.
That would have been more credible had you initiated action against those
Yes.
persons.
Lordship, that's not my submission. But they did not. But in writing, they have to give the notice that be witness. If they refuse, then proceeding has to be done.
Intercept
What passed? Oh, I'm saying that. Grateful, Lordship.
second call
Item number 1.
I don't know
Your other side has come.
Yes.
এটা কি আছে তুমি বলছেন না কেন
Oh, expunge.
অ্যাডভার্স রিমার্কস ঠিক আছে করে দিন একটা কনসার্ন করে দিয়ে বলে দিন যেন মানে ইভেন কনসার্স
This is for expunction. Expunction. Sir, you really have no role to play in this application. We are not touching the bail. We are not touching the bail, but we are changing our remarks. You can have nothing to say there.
Yes, I have nothing to say in respect of that portion, but my lord, in regard to the law, this is the application has been filed for the recalling or modification of the order. 362 of CRPC is very clear. After passing the order, it's a finality form.
Modification, they are not pressing. They are not pressing the
Very
pen.
careful.
They are
No,
not
they
pressing.
are filed for modification of the adverse remarks or observation. This much,
I have nothing to say in
then
regard to that.
take down. I mean,
This application has been taken out on behalf of the state for expunction of certain remarks from our order dated
11/7/2023.
23. Stop. The portion of the order of which deletion is prayed for has been set out in paragraph 3 of the application.
Paragraph, practically lordship of 2. Observation in paragraph 2.
In your application.
Lordship, Malad.
3 of the application, comma, which read as follows. এখানে 3 থেকে দেখবে কোট করা আছে, দিয়ে দেবে order-এর ভিতর। Paragraph. We have heard learned counsel for the parties. Stop. The applicant does not press for modification of the order in any other manner. Stop. Taking a paragraph, taking a lenient view, comma, we allow the prayer for expunction of the portion aforementioned, stop. However, comma, in the same breath, comma,
গোটা এক্সপান্ডার হয়ে গেলে তো এটা পাল্টে যাবে। আমরা শুধু ওই অ্যাডভার্স কমেন্ট যেটা আছে সেই পোর্শনটা এক্সপ্যান্ড করতে চাইছি। এখানে তো আমরা পুরোটা পড়েছি।
ও আচ্ছা, শোনো, যে পোর্শনটা এক্সপাঞ্জড হবে তার বেড়ে দিচ্ছি এখান থেকে, পুরোটা হবে না। সারপ্রাইজ থেকে হবে কি? সারপ্রাইজ থেকে শেষ অবধি, ঠিক আছে, ওইটুকুই হবে।
এই আমি দাগ দিয়ে দিয়েছি, এই পোর্শনটা বাদ দিয়ে দাও, এই পোর্শন থেকে ব্র্যাকেট করে দিয়েছি।
কোট করে দেবে ওখানে, হ্যাঁ? তারপরে ক্লাস কি বললাম বলো? In the same breath, comma, we feel compelled to add that the law officers of the state must take greater care in conducting matters on behalf of the state and act with more prudence. Stop. This we say because we find that the prosecution witnesses who have been examined so far have not supported the prosecution case, but yet have not been declared hostile. We'll stop there.
Lordship, may I in this regard?
Yes.
Because my lord, one judgment I will refer with regards to the hostility when the public prosecutor shall declare hostile, and what would be the consequences, my lord? Just a one paragraph, my lord, may I refer? Then Lordship, it will be clear, Lordship. Lordship, my network was yesterday very weak, but I have brought a book. I could not download the judgment. Lord, it's a 1976, the judgment of the Honorable Supreme Court by my lord Justice Chandrachud, P.N. Bhagavati, and my lord Justice Sarkaria. My lord, kindly see the head note B, paragraph 18. Head note B, my lord.
Let us see paragraph 18. Head notes are
Lordship.
misleading of
Lordship.
Yes. Yes.
Lordship, unless it is a corroboration, my lord, there are other witnesses because the learned PP thought it. Because whatever he has seen and will depose, that will support the prosecution case. Suppose not even declaring hostile. Even the cross-examination, in cross-examination, he will say no. Thereafter, in corroboration, if it is seen that he was not present, then the entire truth will go, my lord. This is the reason, my lord, I am saying of the prosecution end, this is the reason learned PP did not declare hostile. I leave it to your lordships.
Anyway.
Lordship.
In view of such, there is no requirement on the part of the department to forward the copy of the order dated 11/7/2023 either to the legal remembrancer of Government of West Bengal or to the learned district PP Darjeeling.
Lordship.
Happy?
Regard to the no objection in respect of the expiration.
Actor Diyo, learned advocate for the petitioner in whose favor the order of bail has been passed.
In his usual fairness, submits that he has got no objection with regard to the allowing of the prayer as filed in crayon order.
No, my learned friend knows what is the content of the learned PP since 2011. He knows, my lord. So that's what the usual fairness he has submitted.
I don't tell that this application has been filed and sworn by one assistant sub inspector.
IO,
If I'm not wrong.
IO,
While
investigating
that
officer.
investigation is completed, his role is over.
Who will
And
sign?
he is certifying that the public prosecutor is doing
Sir,
well.
on the last day of this circuit, don't get into all those hyper technicalities.
And if I'm not wrong, this has been registered as the CAN. It should be CRAN.
Cran, it has been cran.
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 If I'm not wrong, subject to the correction of the record. This is CAN.
Granny,
It has been
of it.
mentioned as CAN.
No, there is subsequent correction.
Okay, but that's application has been.
Man is, man is subject to error and omission.
Hmm.
And that can be rectified,
It's a-
which we do also.
Lordship, much of Lordship, grateful, Lordship.
Do you know what it means? To err is human. If you don't commit error, you're not considered to be human.
Exactly.
One thing I can assure you, I personally, that I do not carry anything when I get down from my court.
Lordship, this is the.
Whatever it happens, either hot or cold, maybe, but I do not, never in my entire career, I never carry it in my chamber. After getting down, I forget everything.
Lordship.
And there are lawyers should also. do
This
the
happened
same.
also to us also even. We forget everything, Lordship.
That is important to preserve your sanity and peace of mind.
And we learn from that. If
Yes.
it is a mistake, then we learn that and then accordingly we execute it.
Yes.
Grateful, much of it. Grateful.
I has no objection.
Yes.
Item number 3.
3-4 হয়ে গেল না?
Mr. Vishwash, you have photocopy of the CD in 3?
Yes, Lordship, I hand it over.
No. Thank you.
I think Lordship will be carrying it to Calcutta.
Yes, yes.
And the judgments I relied upon. 2 judgments.
Item number 5.
Item number 5, state is present.
On behalf of the petitioner, this is the case under section. This is the case under section 366A, 370, 370A, 506, 34, and read with section 6 of the POSCO Act. Oh, POXO.
POXO Act.
Yes, my lord. Now, my lord, the petitioner number 1.
There was a previous rejection also.
No,
Lordship.
that was not pressed, my lord.
Not pressed.
Okay.
My lord.
Accused.
The petitioner number 1 is 19 years old. The petitioner number 2 is 26 years old. Now, my lord, out of 13 witnesses, 3 witnesses have already been examined. Now, my lord, there are material contradiction of facts in the FIR, in the deposition, as well as the charge sheet submitted by the police officer, the IO. Now, my lord, I would like to draw your lordship attention to page number 9 of my FIR, my lord. The FIR states that petitioner number 1 befriended the victim girl, took her to various places and had physical relation. Thereafter, it says, one said Manik Mondal, the petitioner number 1, with the help of his friend Rahul and Rakesh. There's no mention of petitioner number 2 in the FIR. Took my daughter to Malda, but my daughter understood that they have been trying to abduct her and traffic her. As such, she somehow managed to escape and came back to home. She told me that said Manik Mondal used to take her in a house near Siliguri Junction, where some other girls of her age also there, but never let her talk to them. This is, and thereafter it's also said that he has threatened, blackmailed the victim and have took some objectionable photos of the victim. That is what is the content of the FIR. My lord, page 10 is a deposition of the victim, my lord. It's very interesting, my lord. She says now, name of my friend is Neha. She introduced me with accused Manik Mondal over telephone. Neha gave mobile number of my mother to accused Manik Mondal without informing me. Manik Mondal used to telephone me and talk with me. He told me to state the matter of love to members of my family. The accused told her to tell about the matter of love to the member of her family. I narrated the said matter to my mother. My mother raised objection. So if an accused is going to traffic a girl, if an accused is going to have physical relation, will he tell the girl to tell her mother about the love relation? That's my first question. Now, second is, it says that Manik Mondal took me to Malda forcibly with him. There he established physical relation with me. Another fact comes, accused Pankaj Mondal, the accused petitioner number 2, who is a friend of Manik Mondal, also established physical relation with me at Malda.
Then the allegations are very serious.
My lord, my lord, my lord. See the cross-examination now.
Next line also.
They did videography of their sexual intercourse with me. Now my lord. The cross-examination.
Yes.
That's very interesting. My lord, page number 12. In the cross, she says, line number 1, 2, 3, 4, 5. Fifth line.
Yes.
I did not state to anybody of Toto or train that Manik Mondal was taking me to Malda forcibly. He took me to a village, Adina, at Malda. We got down from the train at Malda station. When I tried to go to the GRP and RPF at Malda, accused Manik Mondal restrained me. We went to Adina from Malda station on a Toto. He took me to a house at Adina by claiming the same to be the house of his relative. One elderly person, his wife and son were there. We stayed there for one day. I stated the wife of the said elderly person that Manik Mondal brought me there forcibly. As accused brutally assaulted me at Adina, I fled away therefrom and reached before a bus stand at Malda.
Ma'am,
My
even for the sake of argument,
My lord.
though this is not a proper forum to assess the evidence,
My lord.
even for the sake of argument, if we consider the portions of the deposition which we have highlighted,
My lord.
at least 6 has been established.
My lord, there
At
is a
least
love
6 has been
relation.
established.
If there is a love relation, my lord.
No, that you cannot say, you cannot shake the witness.
And another question, my lord. Another
Ma'am, it is
Kindly see the charge
better
sheet.
not to say better.
My-
Otherwise, the learned trial court would be prejudiced because everything is being live streaming.
My lord, I will just show your lordship another the portion of the charge sheet, my lord, where the IO have stated something, my lord.
Even if
Can
I'm
you-
telling you,
can
even if we overlook the other sections, ma'am, but section 6 has been established at least prior.
My lord, just see once the charge sheet, my lord. If
Yes.
my lord, the charge sheet, my lord. It's not there in my record, my lord. It could be seen from the CD, my lord. The charge sheet, my lord. আমার চার সাথে একটা পেজই আছে।
Yes.
The charge sheet says the statement of the VG has been recorded under 164 CRPC. The paragraph after that. The report from Inspector in Charge, New Jalpaiguri, had been received where it is found that the victim girl was rescued by Shampa Devnath Sarkar, team member railway child line from platform number 1 of New Jalpaiguri railway station on 11/2/2022. The FIR was lodged on 14/2/2022. She was loitering alone and was handed over to the railway child line for production before CWC. Later, she was kept in Nijoloy home, Jalpaiguri. I examined Shampa Devnath Sarkar, team member railway child line, New Jalpaiguri. She never divulged about such facts to anyone at that point of that moment of time. Thereafter, it says the report from officer in charge, Bagdogra PS, has been received. Where
All
it is-
right, we have seen. Tell us one thing,
My lord.
whether in a deposition, PW, the victim,
Yes,
PW1 or 2,
yes, facts.
no, PW1 has stated anything with regard to the videography.
No, it's not there in the chief. PW1. Yeah, made a victim.
PW1 is
He
the-
has stated about the videography lordship in her deposition, victim girl lordship.
Which portion?
Which
Mm,
question?
আমি বলে দিচ্ছি, দাঁড়াও।
Oh, they did videography of the
Yes, lordship.
Oh. Then the
Mark
case has
করেছি।
become very bad. Not inclined now.
Then I will not press my lord.
Last digit not pressed.
Grateful, my lord.
Grateful, lordship.
দাদা একটু CD টা দেবে?
কত হলো গো? 5 নম্বর না?
Item number 6.
My lord, I am for the petitioner. My lord,
State.
kindly. My lord, page number 18 of my petition, my lord, the memo of arrest.
Non-compliance of 41B.
Yes, my lord. One lady constable has put her signature at column 10.
Page number, sir?
Page number 18, my lord. Annexer P3.
Page number 3. Annexure. Same order. Huh?
Lady constable 1286 Anisa Chetri. She was part of the raiding team. Among my lord, my grounds, my lord, there was one
Yes,
medical
also-
ground also.
Some reports we had called for, no?
Yes, lordship.
Yes.
Department was directed to communicate the order, and thereafter I had spoken to the jailer. The jailer told me that the order has been complied, but they have not, they have approached the SSK hospital through Alipur Women Jail. And they have not received the report from the board of doctors that was constituted, and the observation has already been done, but they have not received the report as yet. This is the information I have
On the
received. from
earlier
jailer.
occasion, you have paid for bail on any other ground.
No, my lord.
Health
On the-
ground.
On the ground of medical, my lord, the order was passed, my lord. Rest of the submission was reserved, my lord. So that's why, since the report has not come, I'm placing my another submission, which is this one, my lord. My lord. Kindly, my lord.
This is the new form or old form, column 10, na? Column 10. বুঝতে পারছি কোনটা?
Column number 10 is
Column number 10.
usual order.
হ্যাঁ, কিন্তু এটা
Non-compliance of DK.
NDPS.
হ্যাঁ, তাহলে
ওই
same.
এই আইটেম নাম্বার 33 সেদিনকে
হ্যাঁ, খালি independent percentage a member of the family or respected member of the family.
My lord, may I explain the order
One B type of document
of this honorable court only.
signature to car for the
column number 10 is not blank. It has been signed by one lady constable.
ready cost. The blank হবে না, ওগুলো blank আছে।
এটা কি বললেন আমরা instead of
Instead of being blank, one lady constable has put.
Who is the member of the family or a respected member of the
instead of a respecting person or member of the family.
Oh, অন্য বেশ কটা independent person রেখা আছে। বুঝলি? তাহলে এটা follow করো, এই order।
তো আমরা কি লিখেছি?
Independent person, correct order। এইটা follow করো, এই দেবো যদি, এই language-টা হবে।
Instead of a respectable person of the local member of the family of the accused, signature of the present two accused petitioners have been obtained. এটা না লিখে লিখতে হবে signature of one lady constable has been obtained. আর এই অ্যামাউন্টটা 25,000 টাকা 20,000 করলো 20,000 independent person right?
না, আমারই হয়েছে ওটা।
Deeply obliged, my lord.
Item number 8.
Seventy views.
একটু এসিটা চালানো যাবে তো?
But I'm for the petitioner.
এসিতে চালিয়ে দাও, তো উপরে আছে চালানো আছে।
চলছে? বন্ধ আছে ওটা।
দেখাচ্ছি
ওটা তো পাওয়ারটা জ্বলছে নাকি? চলছে?
ইয়ে করো, টেম্পারেচারটা বাড়ো, মানে কমাও। দুটো আলো জ্বললে ঘুমতে ঠান্ডা হচ্ছে, এই যে।
But I'm for the petitioner, my lord.
Is item number 8?
8, my lord. My lord, the matter has been filed on 3rd of July, my lord. We are on 14, my lord.
3rd July.
3rd July, my lord. Absolutely not, my lord. Absolutely not.
Be that as it may, but please allow us to pass order. Why the CD has not been produced? Being a CBI, you cannot claim any privilege, sir. Then CBI must have some due regard upon the court. Convey our displeasure. Yesterday also we have passed an order.
রিপোর্ট ফাইল করাচ্ছি।
Next circuit, উপায় কি আছে?
Well, let there be a peremptory direction, my lord, so that the city could be
Ah.
produced on the next bench, my lord, next day.
এসো। This application for bail was filed on July 3,
My lord.
2023. Stop. Today, paragraph, today, when the matter is taken up for hearing, learned advocate for CBI says that the case diary is not available. Stop. Adjournment is sought for. Paragraph. We are extremely surprised at the lack of diligence on the part of the concerned officers in CBI. Stop. 11 days is sufficient time for producing this case diary in court. Stop. The same has not been done. Stop. Today is the last day of this circuit. Stop. The matter has to be adjourned till the next circuit for no fault of the petitioner. Stop. We express our strong displeasure at the conduct of the concerned officers of CBI. Paragraph, on the adjourned date, the case diary must be made available to the court.
Learned advocate for the CBI, learned advocate for the CBI appearing today is requested to communicate this order to the concerned IO for his information and compliance.
Item number 10.
10,
But I'm for the petitioner. My lord, the victim has been served, my lord, but the tracking report reveals that the consignment has yet not been reached, my lord. It's a POXO case, my lord.
next circuit.
Item number 11. I'm for the petitioner, my lord.
Lordship, in this case, I am applying for the CBI, your lordship. Lordship, the CBI, your lordship, public and CBI, your lordship, to file a report, your lordship, I will evaluate in this case. Lordship, this CD is not come, your lordship, but I have received one thing.
Two other co-accused person enjoying bail, my lord.
In this case.
Oh, this is a Ponzi matter.
Ponzi matter, my lord.
Lordship,
I am in custody about more than 220 days. Charge sheet submitted, two other co-accused person enjoying liberty of bail, my lord. Charge sheet submitted, warrant of arrest was issued. I was arrested and two other co-accused person filed a revisional application before this honorable court. Honorable court directed to surrender before the learned CJM. They surrendered and on that day they were released on bail. My lord. They also directed, I also the director of the company. 2 all are on the
Yes, but
same footing.
your
my lord.
involvement may be more, we don't know.
Lordship, in this case, your lordship, this petitioner enlarged on bail and subsequently your lordship, they did not turn up.
Serious,
before the
without
trial
serious,
court, your
we are
lordship. Did not turn up before the trial court and this would that be your-
You
disposed of what-
produce the CD. Where's the CD?
Lordship, then your lordship, they circuit your
Next
lordship.
circuit.
And along with your lordship, they permit to file a report your lordship.
Next circuit.
They are the separate footing, your lordship.
Write a report. Lekho, lekhe no. This is a case under sections 4/5/6 of the price chits and money circulations. Kya? Dekhen. Stop. The paragraph. Learned advocate for CBI prays for leave to file an affidavit of his client. Stop. He says that the involvement of the petitioner in the alleged crime is extremely prominent. Stop. Paragraph. Today being the last day of the circuit, comma, let this matter stand over till the next circuit. Stop. CBI will be at liberty to file a report in the form of affidavit before the next circuit bench.
And if
With advance copy to learned advocate for the petitioner.
item number 13.
আমরা কি করলাম? সেটা দেখবো আমরা কি আছে সেটা দেখে নেবো আমি আমাদের
Madam, for the petition of note.
item number 13.
13, my lord. My lord, a immature love affair between my lord, two teenagers. My lord, the victim, my lord, is aged about my lord 13 years, and my lord, the petitioner, my lord, 22. So, my lord, they have a love affair, my lord.
22 is not a teenager. His medical report, what
Page
statement?
53, madam. Page 53. 164 statement of the victim.
There are signs of
Charge sheet?
Charge sheet file.
Charge sheet
madam.
file.
Framed? No. Charge framed?
That there is no reflection.
No, my lord, charge has yet not been framed, my lord. Charge sheet
The
has been.
PG has not been examined. Naturally,
No, no.
witness action has
Yeah,
not been.
Lordship.
Which is not examined.
But then, my lord, I'm not pressing.
Since it is the last day, we are giving some relaxation.
Sir.
Item number 15.
But I am for the petition. But kindly see page number 8 of my application. Madam, standing on the same footing, 5 accused person granted anticipatory bail. And yesterday also 1 person granted anticipatory bail by this Honorable High Court. I am languishing jail for 24 days. They are granted 6 person granted anticipatory bail. Kindly see the order, page 8 of my application, and this the yesterday order, my lord.
How many accused?
33, my lord. Total FIR name.
What is the incident?
But a fight between two group of same political party. And kindly see the order sheet, page 9. There is a injury of minor injury, madam. It is observed by this Honorable High Court. Those are minor injuries. Page number 9, first paragraph, madam.
Putting a same.
Lordships, actually, it is considered by thrice your lordships, but today CD with not with me, yes, because I have already deposited. But from the earlier order, your lordships, it is found that there is no injury at all, and the political rivalry is.
Our learned advocate for the petitioner and learned advocate for the state. Stop. Para. It is contended that considering the detention of the present accused petitioner for a considerable length of time, and also considering the fact that the other FIR named co-accused persons.
FIR 6, madam, 6 co-accused.
Alright, other FIR named 6 co-accused persons have already been enlarged on anticipatory bail by this court in CRM within bracket A 477 of 2023.
No, another is, that is the another one.
And in CRM within bracket A 536 of 2023. The present application for bail may be considered on the ground of parity. Stop that. Learned advocate for the state, though oppose the prayer for bail, but he does not dispute that the present 3 accused petitioners are more or less similarly circumstanced with the accused persons already enlarged on anticipatory bail by us. Stop. Such being the position, and keeping in mind that investigation has been proceeded for a considerable length of time, we are inclined to exercise our discretion under section 439 CRPC in favor of the present accused petitioner. It is as ordered that the present accused petitioner may fine bail of rupees 10,000 each with 2 registered share like amount, subject to the satisfaction of learned ACGM Dinata, with a further condition the present accused petitioner shall meet the investigating officer as and when called for, and they shall not leave the territorial jurisdiction of the learned trial court till submission in final form. এগুলো একটু রেখে দিন টেবিল। No, কোনটি বলা আছে till ওই ফাইনাল ফরম্যাটে পড়াই আছে। Until further order হলে কি হবে বলতো, ইনভেস্টিগেশন শেষ হওয়ার পরে চলতে থাকবে, আবার যদি ফুটে আসবে মডিফিকেশন চলতে থাকবে।
Item number 16.
I am for the petitioner.
Found out.
Yes, ma'am. I folded the requisition and the clip video. That, my lord, the next one, I folded another one.
This is the last four.
No, no, my lord, there is.
This one,
No. That one.
page number?
There is no numbering at the page, my lord. May I? Come back. Come back.
Okay. Where is the CCTV footage about?
My lord, that envelope, my lord.
Huh?
That envelope. Yes, my lord.
Envelope.
Video clips.
To open it. এটা খুলুন।
There is no reflection in the 172 CRPC, but I found this envelope.
পুরোটা দেখতে হবে, পুরোটা দেখতে হবে।
Nowhere it has been reflected that the present picture.
Pen drive,
Requisitions are there, but there is no reflection in the 172, but I have the video.
লাইভ স্ট্রিম বন্ধ করো, এর অসুবিধা নেই কোনো।
সেটা বলতে পারবো না।
learned advocate for the petitioner submits before this court that the present accused petitioner has got no role in the instant crime. And it is the specific case of the present accused petitioner that by using the Aadhaar card of the present accused petitioner, someone has booked the consignment containing commercial quantity of contraband articles with the NJP RMS, narcotics, narcotic drugs, with the NJP RMS. Stop. While opposing the prayer for prayer for bail, learned advocate for the state requests us to look to the CCTV footage as collected by the IO in course of investigation. Stop. In course of hearing, we have taken out the relevant pen drive containing the CCTV footage from a sealed enclosure, sealed envelope,
Seeing the system footage.
which was kept in a sealed envelope. Stop.
But these are all
On,
video-
on perusal of the materials of the CD, it appears to us that for effective adjudication of the instant application for bail, the presence of the IO in connection with NJP GRPS case number 5 of 2022 is a must. Along with the entire CD, including the pen drive containing the relevant CCTV footage. Stop. Such being the position, let the matter be listed on such and such a particular date. Such and such day before the next available circuit bench. Stop. ACO of this court is hereby directed to keep the pen drive containing the CCTV footage in a sealed envelope. Once again, and
No, this is not the CCTV footage, is it?
pen drive.
No, the mother of quoted CCTV footage initially.
Pen drive, keep the pen drive.
Keep the pen drive in a sealed envelope and return the same along with the case diary to the learned advocate for the state.
That we have directed the IO. Yes, yes.
Stop. On the adjourned day, on the adjourned day, the investigating officer is is directed to come with the CCTV footage as collected by him. If the same is not yet been incorporated in the case diary. Stop. Learned advocate for the state is hereby requested to communicate the server copy of this order to the concerned IO for his immediate compliance. Date ta kobe debo?
24 থেকে যদি হয় তো
24 July থেকে
26 এর মাঝে
26 July দিয়ে দিচ্ছি।
26 July. Sufficient time. এইটা কি নিয়ে
না ফেরত দিতে হবে। হ্যাঁ হ্যাঁ না রাখার কথা কি বললাম, এটাকে তুমি এনভেলাপে মুড়ে সিল করে যেমন ভাবে ছিল সিল করে ফেরত দিয়ে দাও।
এটা বড় টিফিন টাইম এসে নিতে পারে। তখন তুই লন্ড্রি টাইপ বলে সিল করবি।
No, one thing, while Malad we recorded initially CCTV, might have seen the CCTV footage.
We correct it.
Yes, sir.
We correct it.
And Malad, one thing, if it is not with the charge sheet, Malad, can it be,
That will be considered by, that will be considered.
it has to be reflected. in the
CCTV
charge
না,
sheet.
pen drive করো, CCTV টা না in pen drive.
CCTV ফুটেজ কোথাও দেবে না।
CCTV না, ওটা লিখুন pen drive, allegedly to be contained, allegedly to be containing, allegedly containing the CCTV footage. এটা না, allegedly করো। ঠিক আছে? হ্যাঁ, 27.
Already fixing the matter 27.
ওকে যেমন ভাবে ছিল ওইভাবে সিল করে আমাদের গালা আছে হ্যাঁ আছে আছে আছে
হ্যাঁ হ্যাঁ
May it please, my lords. My lords, I beg to appear in 17, my lords. My lords, in the instant case, my lords, my learned colleague will be passing over a judgment, my lords, for your lordship's kind perusal, my lords. My lords, in this particular case, my lords, my lords, am I audible to your lordship?
yes yes
My lords, in terms of section 52A of the NDPS Act, my lords, for disposal, my lords, the statute says that the application for certification in inventory, my lords, has to be made within a reasonable time, my lords. My lords, the Honorable Supreme Court in Union of India versus Mohanlal, my lords, while the direction was given to the central government to clarify the notification in terms of the procedure to be followed, my lords, because the Act is silent on the process of sampling as well as the process of forwarding it to FSL, my lords. There are standing instructions 1 of 88 and 89, my lords. My lords, for the longest time, there was a certain ambiguity, my lords, in terms of what exact procedure needs to be followed.
Considered at the time of trial, my lord. Bail
My lords,
application, my lord.
I have an application, my lords, I have a bail order precisely on this, my lords. My lords, may I please have para 9 of the of the order that has been passed, my lords. I'll only need 3 exact paragraphs, my lords, and then I'll leave it to your lordships.
para 9 of what
Para 9 of the judgment that has been passed over, my lords. This is Kasif versus NCB, my lords. It's a 2023 judgment, my lord, passed by the Honorable High Court of Delhi, my lords. If your lordship may please have para 9.
High Court. My lord, this is Delhi High Court.
My lords, in terms of 1.5, my lord, says place and time of drawal of sample, my lords, which says sampling to be drawn on spot, my lords. In front of, my lords, the independent witnesses, my lords. My lords, and my lords may turn to the next page, my lords, para 1.13, my lords. Mode and time for dispatch of sample to the laboratory, my lords. It says the sample should be sent either by ensured post or through special messenger duly authorized for the purpose. Dispatch of samples by registered post or ordinary mail should not be resorted to. Samples must be dispatched to the lab within 72 hours of seizure to avoid any legal objection, my lords. My lords, thereafter, my lords, para 11, my lords, it says where the Honorable Supreme Court in Noor Aga, my lords, versus State of Punjab, which is a 3-judge bench judgment, my lords, said that standing instructions 1 of 88 is a mandate of law, my lords. Now, my lords, now Mohanlal, my lords, when it talked about 1 of 88 and 89, my lords, it only spoke on the aspect of storage of contraband, my lords, not on sampling, my lords. And in no way, my lords, Noor Aga was overturned by the Honorable Supreme Court. My lords, just one more paragraph thereafter, but the Honorable High Court has in fact answered the ambiguity that has been there in the law in terms of Mohanlal and 188. My lords, may please have para 17 thereafter, my lords. And the heading is resolving the ambiguity, my lords.
para
May I read, my lords? 17, my lords, 17.
17
My lords, it's under the head of resolving the ambiguity, my lords.
yes
My lords. If the argument of the respondents is accepted that Section 52A of the NDPS Act does not contemplate a time frame within which the application is to be moved, the same would be contrary to the legislative intent. It is settled principle that where a statute does not provide for a particular time limit, the same can be inferred from the guidelines or has to be within reasonable time. In Mohanlal Supra, the Honorable Supreme Court in Para 19 has opined that the scheme of the Act in general and Section 52 in particular does not book any delay in the matter of making of an application of drawing of samples and certification. While we see no room for prescribing or reading a time frame into the provision, we are of the view that an application for sampling and certification ought to be made without undue delay. What is reasonable has been left open by the apex court in the said judgment. It cannot be intent of the legislature, since no time limit is mentioned in the statute. The respondent authorities can take their own sweet time in moving an application under 52A NDPS. Rather, the said application should be made at the earliest to prevent the apprehension of tampering with samples, as the seizure quantity and quality of contraband is most crucial evidence in NDPS cases, and drawing of sample and certification in the presence of magistrate is of the utmost importance. Thus, a harmonious and combined reading of Standing Order 1 of 88 and 52A NDPS construes that a reasonable time must be read into 52A2 for making an application for drawing the sample and certification before the magistrate. I'll skip on the effect of delay, my lords. Let's just come to Para 28. Reasonable time, my lords, may just turn over to the next page, my lords. Para 28, if your lordship has that. It's reasonable time under Section 52A, my lords. May I read, my lords?
Yes.
What is reasonable time depends on the facts and circumstances of each case. However, it cannot be the intention of the legislature that an application for sample collection can be moved at the whims and fancies of the prosecuting agency. Therefore, taking cue from Standing Order 1 of 88, it is desirable that an application under 52A should be made within 72 hours or near about the same time frame. In the present case, the application for drawing sample and certification of seizure memo under 52A was filed on so-and-so after 51 days from the period of last seizure on so-and-so. Then, my lords, thereafter, in the next page, my lords, bail is granted in those terms, my lords. My lords, in the present case,
No, my lord, may I?
Please complete. May I complete?
Yes.
Please. My lords, in the present case, my lords, the petitioner is arrested, my lords, on the 30th of June 2022, my lords. Thereafter, my lords, in the charge sheet, and my lords may have the charge sheet in that regard. My learned colleague will also be placing the copy. There's one page that was missing from the charge sheet, which we have to obtain separately, my lords, from the records. My lords may have the charge sheet for a moment, my lords, please. From Para 17, my lords, in the charge sheet, please. If my lords may have that.
Yes.
My lords, the first paragraph is in terms of the arrest and what led up to the arrest of the accused, my lords. And I'll just quickly read that, my lords. The fact of the case in brief is that on so-and-so at so-and-so received a complaint from so-and-so against one Yogendra Singh of so-and-so, driver of so-and-so, to the effect that on 30th of June at around 4:25 hours PM, he received information that one vehicle so-and-so is coming from Assam side and going to Bihar side and is loaded with huge quantity of ganja. Accordingly, after obtaining permissions from superior, he along with force left for so-and-so near so-and-so at NH Kotwali PS at around 15 hours. Identified by source, they detained the above vehicle. One person, as noted above, was found inside the vehicle. Then, in presence of executive magistrate, the search and seizure was done and the whole process is videographed. A total of 8 packets of contraband ganja weighing approx so-and-so was found inside the concealed chambers of the vehicle. Accordingly, it was seized and the above noted person was arrested. My lords, over here, they don't talk about any sampling on spot. My lords, in the next page, my lords, during investigation, I received seizure report, 1 memo of arrest and connected papers from the complainant so-and-so. In course of investigation, I visited PO and prepared rough sketch map and PO and its index. Examined the witnesses and recorded their statement under 161. Forwarded the arrested accused so-and-so to the learned court with 7 days PC remand. But it was learned that due to seizure work, Jalpaiguri, I was asked to come on 4/7/2022, PC remand of accused Yogendra Singh. I sent CA certification and information to the family through mail. On 4th of July 2022, I submitted prayer for inventory. Well, this is 30th of June 2022 is the time, and then submission for inventory is on 4 of 7. Thereafter, the learned court allowed for PC remand on 5/7. Well, for all this duration between 30th 6 to 5/7, when PC remand was not even permitted, it is in fact, my lords, has not been answered where the accused was also kept, my lords. And during the remand period that the accused did not cooperate in investigation, returned back one PC accused learned court Jalpaiguri. Inventory process was held by learned court and photographs of inventory certificates were collected. Well, as they don't mention the day or on which the inventory is also collected or the inventory is made by the Hon'ble court. Then, my lords, on 10th of July 2022, the same are forwarded to CFSL, my lords. My lords, in terms of making an application at the earliest, my lords, that has not been done in the particular case, in the present case, my lords. In terms of compliance of standing instructions of sampling on spot has not been complied with, my lords. In fact, there have been a spate of judgments, and my lords, there is a discrepancy and a gap in law today because, my lords, various high courts hold 1 of 88 to be a valid ground for bail, my lords. And we have a list of, my lords, at least 30 judgments where bail has been granted, and equally when it has not been granted, my lords. But, my lords, what I urge before your lordship is to consider, my lords, when 52A talks about representative samples, my lords, those samples were clarified by Mohanlal in Supreme Court in Mohanlal to be primary evidence for the trial, but not for forwarding for CFSL. And I can take your lordship to 52A and section 55 of NDPS, and there is a judgment by state of Rajasthan though on this, which says that, my lords, what has to be drawn on spot is the sample that has to be forwarded to CFSL, my lords. Thereafter, that has to be done within 72 hours, my lords, in terms of 1 of 88. And then thereafter, my lords, in terms of standing order of the TRI, within 30 days of receive of report of CFSL report, my lords, then the application for, my lords, disposal of the contraband has to be made under 52A of the NDPS Act, my lords. And where a representative sample is drawn, my lords, which will be the primary sample for evidence in the trial, my lords. My lords, the legislature's intent is astute. They have used the word sample in 55 and in 52A, my lords, the word representative sample.
So how much delay occurred in sending the sample?
My lords, the sample, in fact, has been sent on the. They have not mentioned when the sample has been sent. They say they say that on 10th of July, my lords, the sample is sent. That is after a day of my lords, delay of 10 days, my lords.
And when the seizure was made? When the
seizure was made, my lords, the seizure was made on the 30th of June 2022, and my lords, it was forwarded.
20th, sorry.
My lords, 30th of June 2022, my lords, and
30th June, so 10 days. Within 10 days,
yes,
they have sent it.
Yes, my lords.
So
whether
there is a time limit in the statute.
My lords, that's what, my lords, 1 of 88 at para 9, my lords, it says that
No, just we'll definitely look to the judgment. Section 52 says that
reasonable time.
Every person arrested in article seized under subsection 2 of section 41, section 42, section 43, and section shall be forwarded without unnecessary delay to the officer in charge of the nearest police station, officer empowered under section 53. The authority or officer to whom any person article is forwarded under subsection 2 or subsection 3 shall all convenient dispatch take such measures as may necessary for the disposal according to the law of such person article. So, whether in the act, whether there is no time, there is no time.
No, my lords. In fact, my lords, the act, because it was, my lords, silent on the time limit, it's precisely for this reason, my lords, that standing orders have been issued by the court.
Just a minute.
But
madam, what is the time limit that is to be, that will depend upon the facts and circumstances of these cases?
My lords, no, my lords. My lords, in terms of section 52A, if my lords may see, section 52A empowers the central government to also make rules in this regard, my lords. Precisely for this reason, my lords, the central government, the Department of Revenue Intelligence, had come out with standing instructions 1 of 89, my lords. My lords, 1 of 88 has been reproduced here, and 1 of 89 is also finds mentioned in our Bear Acts, my lords. which says within 72 hours it has to be sent for CFSL, my lords.
Why it is there?
If my-
Section?
My lords, it is a standing order, my lords. It is there in the Bear Act, my lords. But it's not
Section
in the
52A.
statute. My lords, with
Say-
section
My lord, may I
52A,
reply, my lord?
well, it's because various high courts have in fact resolved the ambiguity to say that when the statute is silent on something, it's precisely for this reason, my lords, that rules, notifications and or standing orders are taken out, my lords. And if your lordship may pass over the matter, I'll place the standing orders also before your lordship if it's not mentioned in the Bear
Passover
Act,
is not
because I had
possible.
it.
Passover is not possible.
But one in Mohanlal case, my lord, knows better than this already standing order is there.
My lord, standing
But-
instruction, Supreme Court has held that it is directory and not mandatory in nature. Your lordship
my lords.
in this bench, my lord, please, your lordship, my lord, in this bench, I was for the state, your lordship had passed this order that it is directory and not mandatory in nature. So the view has already been taken by your lordship. My lord, same plea was taken before Justice Bakchi's division bench.
And that has been turned down.
That has been turned down. my lord.
No, it is a reasonable time period.
Yes.
What I can interpret it. And in this Delhi case, there was a delay of 51 days.
Yes,
Only 10, it is a 10.
my lord, my lord.
Take down.
Take down.
Well, it's for this exact
We have,
reason. Well, let's
madam,
just,
madam, you
I bow
can't,
down.
ma'am, you can't complain that we haven't heard you. We have
No,
heard
no,
you
my lords,
for
I bow down.
25 minutes,
I
right?
bow down, my lords.
Please kindly allow us to pass our order. Kindly allow us to pass our order.
My lords, just give me 30 seconds, my lords. In fact, my lords, exactly, my lords, in para 11.
Ma'am, let us pass our order. Let us pass our order. We have
Is
heard
a
you.
three-judge bench judgment, my lords.
Bolo, bolo.
In fact, my lords, Noor Aga does not supersede Mohanlal.
Heard learned advocate for the petitioner, learned advocate for the state at length. In support of the instant application for bail, learned advocate for the petitioner draws our attention to the provisions of section 52 as well as section 52A of the NDPS Act 1985, comma, photocopy of the charge sheet as submitted in this case, and the reported decision of Kashif versus NCB as passed by the High Court of Delhi, reported in 2023 SCC Online Delhi 2881. Stop. It is argued that on conjoint perusal of the aforesaid legislative provision, comma, the materials available in the charge sheet and the reported decision of Kashif, comma, there occurred an unreasonable delay in sending the samples, which is violative of the standing instruction of standing order of the Union of India, standing order 1/88 of Union of India, /80 of Union of India.
And in particular clauses 1.5 and 1.13.
Stop. It is submitted that considering the aforesaid aspect, the judgment of Kashif Shupra was passed in a bail application. Stop. While opposing the prayer for bail, learned advocate for the state submits before this court that from the charge sheet it would reveal that no inordinate delay occurred in sending the exhibits to FSL. Stop. It is further submitted that the aforesaid standing order of Union of India is merely directory in nature, and there cannot be, under no stage of imagination, it can be said that it has a force of an act or rules. Under no imagination, under no stage of imagination, it can be said that the said or standing order has a force of an act or of a rule. Stop parallel. We have meticulously gone through the provisions of section 52 and 52A of the NDPS Act 1985, comma, the materials as available in the case diary, including the charge sheet and the reported decision of Kasif as cited from the site of the present accused petitioner. Stop there. Admittedly, in the statute, there is no whisper within which time the exhibits are to be sent. On the contrary, it is the intention of the legislature that such dispatch has to be made without unnecessary delay. That such dispatch has to be made without unnecessary delay. Stop. The term unnecessary delay is a relative term which is to be adjudicated, is a relative term, and there cannot be any straitjacket formula to determine as to when or from what time such delay starts. Stop. Whether there occurred any delay, there occurred any unnecessary delay, is to be ascertained from the facts and circumstances as involved in the case pending before the court. Stop. Prima facie, it appears to us from the materials as placed before, us. Prima facie, prima facie, it appears from the materials placed before us that there was no much inordinate delay in sending the exhibits to the FSL on the part of the prosecution, though in this regard our view is absolutely tentative, and in view of such we consider that the contention of the learned advocate for the petition cannot dilute the statutory restriction of section 37 of the NDPS Act 1985. Stop. In view of such discussion, we are not inclined to allow the prayer. Accordingly, prayer for bail is considered and refused.
I'm so grateful for that. Deeply in love. I'm so grateful.
We'll come back. We'll come back in 10 minutes.
Lordship, the list will be exhausted.
You want it to be exhausted?
Yes, sir. Yes, your Lord.
Then we'd have to sit till 3 o'clock.
No, we'll
That's
exhaust
it.
the list, no issue.
Lordship,
But
grateful, Lordship, grateful. Lordship.
Let us arise for
Grateful,
five or 10
grateful,
minutes.
No Passover.
Actually, what happens, sometimes some arguments become long,
Lordship,
which is why it cannot.
Lordship.
Hey, Saurabh. Saurabh? Hey, Saurabh. Ganguly. Ah. Man.
Item 20, my lord. Make it next service. Service not completed one.
Next, 21. 21.
What is the nature of offense?
Allegation is under section 498 and 328 of the Indian Penal Code, Lordship. Petitioner is the Kakato Deor, cousin brother-in-law, husband is or anticipatory bail, Lordship.
This is the 164 of the.
And the FIR is lodged after 12 days of the incident, Lordship. Kindly see the involvement.
Anything specific against Pankaj Roy?
But my lord, these are my lord, in-law.
Anything specific?
Husband,
Once she has stated that in-laws tortured her, my lord. that-
husband is on
General.
anticipatory bail, page 8.
General. Medical, anything in medical?
Medical, she was admitted to the hospital on 41 till 40.
Why 328 is there? What is the allegation?
Because,
Lordship, the allegation is that husband poured poison in her mouth and the petitioner's involvement, he grabbed the legs, Lordship. Husband is on anticipatory bail, Lordship, page 8.
Is there any material of 328?
My lord, poisoning, page 41 to 48 treatment sheet. She was treatment for my lord, poisoning.
Where is the medical?
Page number 41 to 48, my lord. She was treated for poisoning, my lord.
But is there any statement that they
They administered, my lord.
Administered poison?
My lord, she is the victim, my lord. I have already folded the one. My lord, I have already given the file.
heard learned advocate for the petitioner and learned advocate for the state at length? Stop. Learned advocate for the state who opposed the prayer for bail, anticipatory bail. On perusal of the entire materials of the case diary, on perusal of the entire materials of the case diary, especially the statement of the victim as recorded under section 164 CRPC, it reveals that allegation of administering poison by the present accused petitioner gets due support therefrom. However, considering the fact that the present case arises out of a matrimonial dispute where the chance of exaggeration cannot be ruled out, we are inclined to take a lenient approach. It is as ordered that in the event of his arrest, the present accused petitioner may find bail of is 10,000 with 2 registers like amount, satisfaction arresting officer to meet the arresting officer as and when called for till submission in final form.
Husband is on.
Husband is on anticipatory, page 8, Lordship.
Item number 22. 22, my lord, I appear for the petitioner, my lord. My lord, the
Allegation?
allegation is under 6 and 7, section 6 and 7 of the POCSO, 325, 307, 506, 34 of the Indian Penal Code. Now, my lords, we're pleased to hear it.
Marriage card. Marriage
Yes,
card,
my lord.
invitation card. Yes, state.
Lordship, I have been instructed that marriage was solemnized. In IO, he has inquired the matter and he has obtained information that marriage was solemnized
With
but
another
Lord-
person,
with another person. But Lordship, I have been instructed that this fetus, this baby belongs to this present petitioner only. Lordship, because Lordship, tomorrow is the delivery date of the Lordship, baby, Lordship. Kindly fix the matter, Lordship, in next circuit, Lordship, because Lordship, we have been instructed that this baby belongs to this petitioner only, Lordship.
Next
My
circuit.
my lord, one humble prayer. In the meantime, kindly grant a limited protection, my lord. Kindly grant a limited protection, my lord. Till the next date, my lord, I may not be arrested. An interim protection, my lord. Great.
Sure. Her learned advocate for the petitioner, learned advocate for the state. at length. In course of his submission, learned advocate for the petitioner submits before this court that with some malafide intention in the written complaint, it has not been disclosed that the victim lady, victim girl has already been married with another person prior to the alleged incident, and out of the said marriage, she became pregnant. Stop. In support of his contention, he has annexed the marriage invitation card, annexed a marriage invitation card. Stop. While opposing the prayer for anticipated bail, learned advocate for the state, though admitted the previous marriage of the victim with another person prior to the alleged incident, but it is a contention on instruction. It is a submission on instruction that the victim girl has been impregnated by the present accused petitioner, and tomorrow is the date of delivery of the said baby by the victim girl. Stop. As such, learned advocate for the state requests this court to defer the matter before till the sitting of the next circuit. Stop. Prayer is considered and allowed. Prayer for deferring the case is considered and allowed. Let the matter be placed before the next circuit.
Grateful, Lord.
In the meantime, there shall be an order upon the investigating officer not to arrest the present accused petition.
Grateful, Lord.
Grateful.
Till the next date of hearing.
Till the next date of hearing. Yes, till the next date of hearing.
Item number 23.
My lord, I'm for the petitioners.
What is the nature of offense?
306, my lord.
306.
498,
498 and 303 and 4 of the Dowry Provision Act.
304B is there, my lord.
304 is there.
304B, my lord. My
Who are you?
apologies, my lord.
I'm the mother-in-law and brother-in-law. Petitioner number 1 is the mother-in-law and petitioner number 2 is the brother-in-law. The only allegation is physical and mental torture, and nothing is.
Husband is in
My
jail.
lord.
No. He enlarged on bail
He has
My-
been enlarged on bail.
by the learned lower court.
Charge sheet.
Submitted, Lord.
Submitted.
Sheet, my lord. Charge sheet has been submitted, my lord. It has
Stop.
been submitted.
Or learned advocate for the
Nature.
petitioner and learned advocate for the state who opposes the prayer for anticipated bail.
Original.
Stop. It is contended on behalf of the on perusal of the entire materials of the case diary. It reveals to us that the allegation as made out in the FIR,
Original.
though gets some support in course of investigation, but prima facie it appears to us that those are omnibus in nature. Stop. Investigation has already been completed. Investigation has stated to have been completed in the meantime. Stop. Such being the position, the custodial detention of the present accused petitioners are no more necessary either for the investigation or for the trial. Accordingly, prayer for anticipated bail is allowed. In the event of their arrest, 10,000 with true registered like amount, satisfaction, learned
Additional Chief Judicial Magistrate Siliguri.
ACJM Siliguri this month, with the further direction that the present accused petitioners shall appear before the learned ACJM Siliguri within 21 days from the date of uploading of this order in this hard.
Grateful, Lord.
Item number 24.
I begs to appear on behalf of the petitioner, my lord.
Nature of offense.
My lord, this is a case under section 323, 341, 354, and 336 and 34 of the Indian Penal Code, my lord.
Is there any material 354?
Out of a
So
land,
as-
my lord, out of a land dispute,
326 is there?
336, my lord.
Oh,
336.
336, okay.
336, my lord.
326, I will be my.
My lord, so far my instruction is 336. My lord, out of land dispute, one Salishi had been held, and my lord, in the Salishi, this present incident has been happened. And my lord, after 5 days, the FIR had been lodged and implicated my family. And my lord, other two accused family member are already on bail by the anticipated bail by
What
the
is
court.
what is your name?
My lord, I am Imran Hossain, allied Imran.
You are named in the Imran.
Yes, my lord.
You are accused number 1.
Yes, my lord.
Allegation is 1 নম্বর আসামি দাও চাকু লইয়া চড়াও হয় ধরালো আমার অস্ত্র দিয়ে আমার ছেলেকে প্রাণে মারার উদ্দেশ্যে মাথায় প্রচন্ড আঘাত করে। What is the injury report?
My lord, kindly see annexure P1. See page number 8. Granted anticipatory bail by the other co-accused person.
No incarceral hemorrhage or concussion. No depressed fracture at left parietal bone. Scalp swelling. Non-depressed fracture. Fracture হয়েছে।
Admitted হয়েছিল?
হ্যাঁ, admitted হয়েছে। এটাই আসল সিটি স্ক্যান।
হ্যাঁ।
Non-depressed fracture is noted at the left parietal bone with scalp swelling. কি হবে আমার?
এসো। The petitioner says that the incident was an outcome of a land dispute. Stop. He had no role to play in the incident. Paragraph, we have seen the material in the case diary, including statements of witnesses as well as the injury report. Stop. Charge sheet?
Not yet been submitted.
Not filed. Stop. The petitioner says that two of the
Other
co-accused
persons
persons
already granted
have already been granted anticipatory bail by
by the
this
lower
court,
court below.
by the land trial court.
No,
Stop. Paragraph on an overall assessment of the material on record, comma, the nature of injury and the possible extent of complicity of the petitioner in the alleged incident, comma, we are of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the investigating officer. Paragraph accordingly.
10,000 arresting officer to meet the investigating officer of this case as and when called for till submission in final form. হ্যাঁ। 432 compliance তো হবে, সবকটাতেই হবে।
My lord, satisfaction of ACGM Dinhata.
No, arresting officer.
Arrest.
430 তে কিন্তু সবসময় 432 compliance হবে না।
I'm for the petition. My lord.
Nature of allegation,
Allegation pelting of stone to the police vehicle, my lord.
is there any injury?
And no injury, my lord. Charge sheet submitted, other on our bail, my lord.
Charge sheet submitted.
Yes, my lord.
What is the injury?
Any injury? Nothing.
Heard learned advocate for the petitioner and learned advocate for the state at length who opposed the prayer for anticipatory bail.
As I found, lordship, he is not wanted in this case.
Not wanted. Then
No, my lord. Charge sheet submitted, warrant.
Charge sheet, charge sheet, his name is not.
I named in the FIR.
then it has got no.
No, my lord. I have specific instruction, my lord. Charge sheet against me and warrant was issued. I am FIR name accused person.
What is your name?
Anarul, my lord.
Anarul Islam.
Anarul Haq.
Anarul Haq, Anarul Islam is there, lordship, not Anarul Haq.
No, you are not in. You are not here.
No, my name in the.
Not
charge
even
sheet.
in the charge sheet, lordship. There is a list of the absconding with
yeah.
accused persons.
My lord.
At the bottom of the charge sheet, lordship, there is a list.
Yes, I have seen. Stop. At the very outset.
My lord, kindly.
First will be served even if you are not wanted.
My lord, father name is Sofikul Islam, my lord. Kindly see.
Warrant was issued.
No, then it should be mentioned clearly.
My lord, kindly, if your lordship don't pass in, kindly adjourn, I take specific instruction. If he's not wanted, he cannot.
No, actually what happened, his father's name is matching.
Father's name is matching.
But take instruction that whether Anarul Haq, alias Anarul Haq or Anarul Islam are the same identical person or not.
Next circuit করে দাও তো।
Next circuit.
Next second.
You can amend the name also, no
Yes,
issue. But the father's name match.
But his name is not appearing there.
It may be that he has father or not.
Yes, my lord.
Before your lordship takes 26, I made a mistake while doing the matter 24. It's the section I have incorrectly written 336. It will be 326. I checked out from the FIR.
320. What are
It would
326
be
for them?
326. Lordship liberty may be
336 or
granted.
326.
I mean the cost type.
You know, just yourself.
24 নম্বর লিবার্টি অ্যাড করে দাও লিবার্টি গ্রান্টেড টু leave is granted to learned advocate on record for the petitioner to correct the sections of IPC mentioned in the cause title of the petition by substituting section 336 by section 326.
ওটা প্রথমে আসবে 26.
Make the correction now immediately.
What is the nature of offense?
Lordship, to cut short the time, it's 326, 307. The patient was treated in emergency and simple in nature. This is the
Stop. Hard learned advocate for
original
the
case,
petitioner, learned advocate for the state at length. Who, however, opposed the prayer for anticipated bail. Stop. On perusal of the entire materials of the case diary, it reveals to us that privacy, there are no materials as against the present accused
Petitioners, your lordship.
petitioner to attract the provision of section 307. Petitioners, there are two petitioners. Then at least privacy. Considering the circumstances. 326/307. 307. Stop. Considering the circumstances and also considering the fact that investigation
Lordship is going on.
it has been progressed substantially. We are inclined to allow the prayer for anticipatory bail. 5,000 in the event of his arrest, their arrest 5,000 with 2 days to the like amount. Satisfaction arresting officer. 432 compliance to meet the investigating officer of this case as and when called for.
Grateful, Lordship.
27.
I'm on behalf of the petitioner.
Nature of offense,
My lord, 498A, 325, 326, 307 and 34.
is there any injury report?
The marriage was solemnized on 2018 and after.
Ma'am, is there any injury?
Yes, lordship.
What are the nature of injury?
Lordship. Lordship, cut injury over lower chin.
This is
Only.
totally, this is
Only, lordship.
totally I am for the mother-in-law, lordship, husband enlarged on bail.
Page number,
25.
investigation completed.
Lordship,
Who are you?
mother-in-law.
Hard learned advocate for the petitioner and learned advocate for the state who vehemently opposes the prayer for anticipated bail. On perusal of the entire materials of the case diary, it appears to us that the present case is the outcome of a matrimonial dispute. Investigation is stated to have been completed in the meantime. Stop. Such being the position, we are of considered view that the detention of the present accused petitioner is no more necessary either for the investigation or for the trial. Stop. In view of such, we are inclined to allow the prayer in the event of an arrest. Not necessary, yes. In the event of an arrest, the present accused petitioner may find bail of rupees 5,000 with 2 registration like amount, subject to the satisfaction of which court? CGM or SCM?
CGM Kuchbehar.
CGM Kuchbehar. 432 compliance with a further direction that the present accused petitioner shall appear before the learned trial court within 21 days.
Great, great.
28.
I'm for the state, your lordship. My lord, I am for the petitioner.
Nature of offense?
This is a, my lord, my lord, allow me kindly.
Previous.
This is a matter of Mr. Sudipto Panda. He has instructed me, he is present online and he has instructed me to do this matter, my lord. Now, before coming to this matter, my lord, I would like to draw your attention towards the synopsis of this case.
Sir, we are hard pressed for time today. Keep that in mind, please.
My lord.
If you want, we can save the matter today. Because we have to come, we have committed to conclude the matter.
I will do this matter, my lord. My lord.
But be brief in your submission. Be brief and concrete.
I am brief in my submission, my lord. My lord, I am charged under section 341, 325, 326, 427, 435, 307 of Indian Penal Code, 3 and 4 of the Explosive Substance Act 1908. Now, my lord, if my lord may come to the written complaint of the FIR, written complaint of this petition, in the petition it is stated that, my lord, I have bombed certain, my lord, may I, my lord?
Yes, we are listening.
Oh, yes, my lord. My lord, that I have bombed the complainant, and I have beaten him, brutally beaten him, and they have escaped from there. They have escaped and went to the public hospital. From public hospital, I have again dragged them, tied to a vehicle, a bike.
Charge sheet?
Charge sheet
CS is pending.
Charge sheet is pending.
CS is pending.
Pending.
My lord, this event.
This is
What
the
is
case
it?
of,
What is his role? His role?
this is very serious, my lord.
Very serious.
Yes, my lord. He assaulted those victim with a sharp cutting weapon. Not only that, they ransacked the 6 number of motorcycle of the victim, and they also thrown bomb. And bomb injury is there, my lord, is a severe injury. At page 79 of the injury report.
My lord, may I be allowed to contradict the point?
Yes, yes. Make your
My lord,
fast.
Bomb
yes,
blast
my lord.
injury is there.
My lord, if I am doing a bomb
Injury is
blast
severe,
injury,
my lord.
then there must be a seizure. A seizure as to the nails of the bomb which have been dropped there.
Come.
Nothing was recovered from
Yes.
there.
Yes, my lord.
And my lord,
Hard learned advocate for the petitioner, learned advocate for the state at length. It is contended on behalf of the petitioner that the allegation as made out in the FIR
Very serious.
is not at all correct. And the present accused petitioner has been falsely implicated in this case. Stop. While opposing the prayer for anticipatory bail, learned advocate for the state draws attention of this court to the injury reports of the victim, wherefrom it reveals that the victims of the incident suffered serious bomb injury on their respective persons. Stop. It also reveals from the statements of the witnesses as recorded so far that the involvement of the present accused petitioner is prima facie prominent. Considering the seriousness of the crime,
12 number of incident is there.
Considering the entire circumstances, we are not inclined to exercise our discretion in favor of the present accused petitioner, and accordingly prayer for anticipatory bail is rejected. Next.
I'm grateful to your lordship.
29.
29, I am appearing, my lord. Can your lordship hear me, my lord?
Yes,
Am I
yes,
audible?
yes.
The signal is very poor here. Your lordship can hear me?
Yes, we can, Mr. Panda.
Yes, my lord. Allegation under 448, 323, 307, 506, and 427. Read with 135 of the Electricity Act. My lord, the prosecution case is this, my lord. At 2 o'clock of the night, I entered somebody's house, the de facto's house, and I tried to hook from 440 connection and tried to electrocute him. And then he managed to save himself, and then I threatened him with dire consequences.
Is there any?
This is the allegation, my lord. Your lordship will kindly come to the FIR.
He was electrocuted.
No ingredient, nothing of that
Mr.
sort.
Panda, one second,
How-
one
what
second.
is the
one-
history, my lord? Why should I go to
Mr.
somebody's house
Panda.
at 2 o'clock in the night? Why should I? Why should?
Please,
Yes, my
please,
lord.
please.
There is no injury regarding electrocution, my lord.
There is no injury,
injury,
nothing
no
of
injury.
that sort, my lord.
Hard learned advocate for the petitioner and learned advocate for the state at length. It is on perusal of the entire materials of the case diary we find no
Nothing in
material.
the FIR, my lord, if your lordship sees, my lord. Absolutely
No
inherently
material to-
improvable allegations, my lord.
substantiate that the victim of the alleged incident suffered electrocution at the instance of the present accused petitioner.
He is not
Stop.
electrocuted, my lord.
Admittedly, there are some other incriminating materials as against the present accused petitioner. But
So
in
nothing,
our
your lordship,
consideration,
your
those are
lordship
not
will kindly see the
sufficient
FIR, my lord.
for rejection
No.
of the prayer for anticipatory bail. Stop. In view of such, it is ordered that in the event of his arrest, the present accused petitioner may find bail of rupees 5,000 with 2 registered suit of like amount. Satisfaction arresting officer. Charge sheet not submitted, no?
No, my lord, charges are not in.
Satisfaction arresting officer, 432 compliance with a further direction that the present accused petitioner shall meet the investigating officer of this case as and when called for till submission in final forms.
I'm grateful, my lord. I'm grateful. I'm deeply obliged.
Much obliged, my lord.
No Poksho.
Initially, two missing diary was lodged, after three.
Who has been taken away?
Complainant,
Son.
yes, allegation that after 3 months, they have they lodged their complaint. Lodged that there's an apprehension, their allegation only apprehension of.
What is there? Victim has been recovered.
Victim has not been recovered.
Victim has not been recovered.
No, my lord.
Then we are not going to grant. You are named in the FIR?
Named in the FIR.
The FIR after
Serial number 2.
FIR.
No, no.
After 3 months.
Victim was not required.
Rishwadi?
Yes, what do you want? Next,
My
sir.
lord, in that case, we are ready with all cases next. Not loss.
Next.
The grace for the last.
My lord.
Next.
Has happened in the examination of our Jalpaiguri Law College.
My lord.
Sir, 5 minutes time. More
My lord, I am also from Jalpaiguri Law College. I passed out in 96, my lord.
Okay.
Item number 31.
I put the petitioner, lordship. Lordship, allegation under section 498, 376, 511, 34 of the dowry prohibition act, lordship. Lordship, the present petitioner.
Why 376 is there?
Lordship,
Who are you?
I'm the father-in-law of the.
Oh my
My
God.
lord, allegations of rape is there in 164, but no medical, my lord.
No.
No medical, my lord.
Lordship, I'm
Victim refused the
73
medical.
years old age person.
Would you continue your submission if we allow your prayer? Please take your seat.
Time waste, time waste, don't waste.
Take down. No medical.
No medical. Victim refused the medical.
Heard learned advocate for the petitioner, learned advocate for the state at length. Stop. Learned advocate for the state, however, opposes the prayer for anticipatory bail. Stop. On perusal of the entire materials of the case diary, it appears to us that the allegation as against the present accused petitioner, allegation of commission of rape. Just please hand over the CD, relevant portion. Allegation of rape as made out in the FIR as against the present accused petitioner, though gets due support in course of investigation, especially from the, what is the 164?
164 is the page number, my lord. 19. 19 of the
Especially from the statement of the victim lady as recorded under section 164 CRPC, but charge sheet submitted.
charge sheet, no, my lord.
But considering the fact that the present case is the outcome of a matrimonial dispute, where the chance of false implication and exaggeration cannot be ruled out, we are inclined to allow the prayer. Keeping in mind, not any, full stop. It is thus ordered that in the event of his arrest, the present accused petitioner may find bail of rupees 10,000 with 2 registered shares of like amount, attesting officer 432 compliance to meet the investigating officer of this case twice in a week and obligor as and when called for till submission in final form. Little bit allegation is grave. Huh?
73 years old.
73 years or like the as and when called for. Allegation is serious. Learned counsel for the state.
My lord,
Allegation.
my lord, allegation is serious, my lord. Till the time my lord, charge sheet will be submitted, my lord, then he can pray for more.
No, he'll meet the investigating officer. Yes, next.
32, my lord, I am for the state.
The allegations are under section 304, culpable homicide not amounting to murder. Lord, this is a outcome of a political rivalry. I do beseeching your lordship to see the complaint. It is alleged that at 11:30 hours in the day, night, that some persons came to the house and assaulted the victim.
Where is the written complaint?
Written complaint, Lord, I have not annexed, but I
Then?
have stated, Lord, in my application at paragraph 4.
Hmm.
Now, Lord,
Rejected.
It was rejected.
Lord, the change in circumstance is the cause of death is heart attack, not Lord for any assault. Lord, initially, Lord,
Is it so?
it has been.
Is it so?
My lord,
I just-
as per the medical, my lord, it is a
It's a heart attack, but
Heart
he was
attack.
suffering from. He has suffered a heart attack 2-3 months back. Now again,
My lord,
on that
kindly-
day-
Page.
Just
Page
be-
318,
Mr. Ahmed,
my lord.
wait. Page
318,
My lord, I am on behalf of the de facto complaint.
318.
my lord.
was admitted in hospital with chest pain.
No, this medical report is after.
318 what?
Medical report of Maharaja Aggression Healthcare Center.
No, where is the
Hereafter, my
medical
lord.
report? No, where is the PM report?
PM report, my lord, kindly peruse. PM report, my lord, page 42.
That will actually give
Yes,
us
my
the
lord,
clear
yes.
picture. Page?
Page 42, 42.
Page 42.
Yes, my lord.
What does it say? Cause of death kept pending till the receipt of chemical report? No.
And thereafter, my lord, chemical report comes.
Huh.
There is no detention, and thereafter, my lord, histopathological also there, my lord. Kindly peruse, my lord, histopathological.
Normal day.
Is there any report saying heart attack is the cause?
Yes, heart attack is the cause, but can't be.
Heart attack is the cause of the death. Who says?
The fact remains, but may I just indicate one thing? Like, even if there is an assault, even if there is the push, that is not the cause of death. Cause of death is not heart attack. And he himself was admitted in hospital on the previous day with a symptom of chest pain. There was no indication of the incident. Now suddenly, after that death, since I'm a political man, everything turns into a common political thing, and and out of 9, 8% has been granted anticipatory bail by the court.
Be that as it may. Your application, Mr. Ahmed, you know better than me that in an application under section 438, subsection 2, 438, for the second time, you have to show the change in circumstances which we could not place because at the time of hearing of the first application.
Charge sheet was not filed initially with the opinion
Charge
that
sheet is not.
that the death, cause of death is heart attack.
What is your submission?
That prompted me to.
My lord, I am on behalf of the de facto complaint. On 13/6/2023,
May I
the
just indicate-
petitioner's 438 application was rejected on merit. And
Yes.
after perusal the all relevant documents and if FIR itself contains that the assault was made on 25th and he was admitted on 26th June. And on the subsequent day, the deceased died at hospital.
May I just indicate another
Before
fact?
ballot.
The
On the
PO
day-
sheets even,
On,
Place of
on the next
occurrence.
date of assault, on the next date of assault, he was died. And I have handed over
Fear of
certain
severe chest pain.
Yes, my lord.
Where is the cause of
Only,
death?
only, no, this is the not cause of death, my lord. Only, my lord, prosecution case is corroborating, my lord. That is the 161 statement. The present petitioner kicked on his chest.
Now, Lord, there, Lord, I join Lord and issue subject Lordship kind sanction. The place of occur, Lord, kindly see, Lord, kindly, Lord, kindly appreciate one aspect.
Enough, Mr. Hamid,
Kind,
enough.
one, the PO as indicated in the FR is
You
Lord,
are a
house.
senior lawyer.
30 seconds, Lord.
Learned advocate for the
PO is at home, but later on, Lord, all statement, Lord, will be saying that at his outside home at 11:30, he was loitering. But a heart patient, how could he be loitering,
Heard
Lord,
learned
in
advocate for the
11:30 PM?
petitioner. Stop. Also heard learned advocate for the de facto complainant and learned advocate for the state. Stop. It is contended on behalf of the petitioner that the instant application for anticipatory bail has been moved for the second time in a changed circumstances which could not be known at the time of disposal of the similar such application by a coordinate bench of this court as filed under section 438 CRPC. Stop there. Learned advocate for the state, learned advocate for the de facto complaint, however, opposes such bail. It is contended that in course of hearing, nothing could be placed to substantiate that a change of circumstances occurred for entertaining the instant application for anticipatory bail for the second time. Learned advocate for the state in course of his submission draws our attention to the various materials of the case, especially the medical examination report of the victim. Stop there. On perusal of the entire materials of the series, we do not find any material to come to a prima facie finding that the that the victim's death occurred on account of heart attack as claimed by the learned advocate for the petition. On the contrary, we found sufficient materials to substantiate the allegation has made out. We found sufficient materials in the CD to substantiate that the present accused petitioner assaulted the victim on her chest, resulting to his death. Stop.
That's an allegation.
Considering the entire circumstances, we are unable to accept the contention of learned advocate for the petitioner that he is successful in making out a changed circumstances for entertaining the instant application for bail, anticipatory bail for the second time. And on this score only, the instant application for anticipatory bail is refused.
Yes. Time for the petition.
Allegation.
My lord, allegation under section 417, 376, 315, and 34. My lord, the petitioner and the complainant, my lord, had a love relationship. Now, my lord, the complainant, my lord, consistently, my lord, put pressure upon the the petitioner, my lord, to solemnize the marriage. On that plea, my lord, the petitioner took time, my lord. My lord, all on a sudden, my lord, the complainant lady, my lord, appeared on the petitioner's house, my lord, and put herself in a dharna. And my lord, thereafter, this complaint has been lost. There was a consistent pressure, my lord, to solemnize the marriage. My lord, the petitioner didn't deny, my lord, to solemnize the marriage, but there was a, my lord, consistent pressure.
My lord,
Why 315 is there?
315, my lord, because she was pregnant, my lord, because of that act, my lord. 417, promised to marry, she was pregnant, but the IO could not procure the documents regarding, my lord, medical for abortion, my lord. Section 91 was served to her, but medical documents she could not provide that regarding pregnancy and the termination of pregnancy, my lord. And the medical was.
76 are there in the statement.
Yes, my lord.
But they are, my lord, consenting party, my lord.
417 and 376 is there, my lord.
Yes, yes. The petitioner says that he had a long-standing relationship with the victim girl. Age of the girl?
Age of the girl, my lord.
He's a major.
Major.
Victim lady.
Lady,
Stop.
my lord.
22 years.
The lady is 22 years old. Stop. The petitioner says that he has been falsely implicated upon. He denying to marry the victim girl, victim lady. Paragraph. We have seen the material in the case diary, which has been placed before us by learned state advocate while opposing the prayer for anticipatory bail. Paragraph. We have seen the statement of the victim lady recorded under 164.
161.
CRPC. Stop. The medical report could not be placed before us. Stop.
Regarding the, my lord, pregnancy, my lord, medical is there regarding.
Medical report regarding pregnancy could not be placed before us.
Regarding pregnancy or termination of pregnancy.
Yes, my lord.
Pregnancy / termination of pregnancy. Yeah? Could not be placed before us. Stop. Paragraph. So charge sheet.
Charge sheet, no, my lord.
On an overall assessment of the material on record and the possible extent of complicity of the petitioner in the alleged offense, we are of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the investigating officer. Paragraph accordingly.
In the event of his arrest, with 10,000 with 2 registers your like amount, satisfaction arresting officer, 432 compliance to meet the investigating officer of this case. Once in a, as and when called for, till submission in final form.
34, I put the petition, initially, this is a case and counter case. Initially, my niece lodged a complaint against the Millard, the de facto complaint and other further under section 341, 326, 34, and section 25 and 27 of the Arms Act, Millard. Subsequently, Millard, they have lodged the Millard entire family, including me, Millard, the instant FIR, Millard. The fact of the case, Millard, my niece, Millard, named Sarjuna Khatun, husband, injured with a gunshot injury, Millard. Millard, she lodged an FIR, Millard, and the counter, Millard, the instant FIR has been lodged.
My lord.
Bullet injury is there.
Bullet injury is there, and this petitioner filed another petition, item number 30.
What is the
same petition? Same petitioner, my lord.
Connection, Millard. That case,
Same
Millard,
petitioner.
that
Same case.
Not fair. No, not same case.
All right. Gunshot injury is there.
Yes,
Well,
yes.
gunshot injury.
Principal accused.
My niece husband was injured, Millard.
His name transport in
Case counter case.
161 statement, my lord.
My niece husband was injured,
If I
Millard.
named accused, my lord.
Millard, kindly,
Mithun Mia.
my involvement, Millard. My name is Mithun Mia, Millard.
23, 24, 25, 97, 106, 148.
Millard,
Why is
my
164?
161 statement, my lord. 161.
161. Gunshot injury আছে দেওয়া যাবে না। আসুন। Our learned advocate for the
Millard, your
learned
lordship is-
advocate for the state.
is allowing or
No, rejecting, we are rejecting.
Millard, then your
No, it cannot be. It's a gunshot injury, it cannot.
Millard,
Our
my
learned
niece
advocate for
husband
the
was injured,
petitioner
Millard.
and
Kindly see who
advocate
is
for the
injured, Millard.
state
Kindly, Millard.
who opposes
Millard,
the
then we are
prayer
not
for
putting the application. Millard.
anticipatory bail.
Millard, they are not placing the application, Millard.
Not pressed.
Great, Millard.
35.
Second number 35, pair for not circuit, next circuit lordship.
Next circuit.
36.
Please call the ma'am. For this circuit, you have been excused. You are junior to Mr. Bhomik, no? But in the next circuit, I like to see that you will move the case. How long you are practicing?
8 months. 8 months.
Okay. You are excused, but from the next circuit, I must see that you personally move the case.
Okay, that's it.
You know, it matters little to us who are moving before this court. It matters much to us what are being moving before this court. So be rest assured that you are a junior, so you will not get an order either favorable or non-favorable. Is not that. Be courageous, but don't be reckless also. Yes.
36.
But I'm for the petition.
Nature of allegation.
My lord, pertaining to my lord pre-existing my lord business dispute my lord, this my lord complaint has been lost. My lord, the complainant my lord borrowed few amount of considerable amount of money from the petitioners my lord, and my lord the petitioners my lord consistently my lord pressurized them my lord to return back, and thereafter my lord this allegation has been my lord leveled.
Yes.
Is there any allegation of demand of ransom?
Yes, my lord. Over telephone, they demanded money from the de facto company, that is the wife of the deceased. He has been kidnapped on 21st. Then on 22nd, they demanded money.
Arthik Rasi Pradhan Korea.
Wife of the deceased.
Names, their names are appearing.
Yes, ma'am.
No, wives of the victim. Victim has been recovered in the meantime.
Yes, my lord.
Ah,
Victim has been recovered.
His names are appearing.
Yes, my lord.
Not
164 of the victim is there, my
not
lord.
inclined.
My lord, no injury, my lord, nothing, my lord. My lord,
Page 16, my lord.
my lord, nothing, my lord.
Be that as
My lord, there was a pre-existing my lord business.
Page, my
tell
lord.
us, will reject or will withdraw. Not in the next circuit.
My lord, withdraw.
Ransom and give.
37.
$37, who's for the state?
Yes.
363, 366. And
Names are appearing.
no, next circuit, next circuit.
Huh?
Yes, my lord.
Next circuit.
Next circuit, no, either reject or withdraw. No.
164 of the
Ransom we will not.
Not ransom. Kindly see, kindly considering the material, thereafter your lordship passes the order. Charge sheet submitted and the victim girl was recovered. Kindly see this
There is
statement.
no demand of ransom.
No, my lord. Kindly see this statement, thereafter your lordship passes.
Lost light.
Kindly see the ones.
What is your submission?
No, my submission, my lord, known person for this reason, they came to the friendship for this
She
reason.
voluntarily went.
Yes, my lord. My lord, charge sheet submitted, long way recovery,
victim was
and
kidnapped.
for this reason, my lord, so far as the
Kindly
allegation
consider
concerned,
the
custodial.
statement
আসুন।
161 statement.
Charge
Actually,
sheet submitted, charge sheet, he'll face the trial. Or learned advocate for the petitioner, learned advocate for the state, who opposes the prayer for anticipatory bail. Stop. On perusal of the entire materials of the case hearing, it reveals to us that the allegation as made out in the FIR, which is really serious in nature, gets due support in course of investigation, especially from the statement of the victim as recorded under section 160 of CRPC. However, considering the fact that investigation has been completed in the meantime, and also considering the fact that this is not a fit case for custodial trial, we are inclined to allow the prayer with some stringent conditions. It is as ordered that the present accused petitioner, in the event of his arrest, may fine bail of rupees 15,000 with 2 registered suit like amount. Satisfaction which court?
CJM Jalpaiguri, my lord.
Satisfaction CJM Jalpaiguri, with a further direction that the present accused petitioner shall appear before the learned trial court within 21 days from the date of uploading of the Sabujada. It is further ordered that the present accused petitioner shall not leave the territorial jurisdiction of the learned trial court till conclusion of trial, unless such condition has been relaxed by the learned trial court. It is further ordered that the present accused petitioner shall not cause any threat or intimidation, shall not cause any threat and oblique or intimidation, and oblique or cause any inducement either to the victim or to the family members.
Thirty-eight, I'm praying for next circuit, my lord. 39. And I am for the petitioner, my lord. I'm for the state. It is for the 39. Statement of co-accused person, I implicated, nothing was recovered, and another co-accused person enlarged on anticipatory bail by this honorable bench, my lord. I already annexed P2, charge sheet submitted, my lord. Nothing was recovered from my possession, my lord.
Yes.
Lordship, though it is true that the name of this petitioner has been transferred from the statement of the co-accused, but
No recovery.
no recovery. But I have a submission to make. Lordship knows in Tufan Singh, where he says that co-accused statement has no evidentiary value. Subsequently came Nawaz Khan, where Justice Chandrachud stated that if any connection can be established, like CDR or something like that, then bail cannot be granted. The connection is established.
Even if there is no recovery.
Even there is no recovery. Then comes Lordship Arimutu's judgment, where 3 judges bench led by Ramana, Justice Ramana, and author was Hima Kohli, where it says it brings back Nawaz Khan. Latest judgment is this one. This is an application of 438, Lordship. But it says para 4, para 8, and para 9. This judgment was given by Justice Indira Banerjee. In Tufan Singh's judgment, there are 3 judgments, and this is an application of 438. Justice Indira Banerjee was dissenting opinion, my lord. There are 3 judgments, Tufan Singh, my lord. I have this citation, my lord. 2:1. Justice Indira Banerjee was the dissenting opinion. Yes. And this is not Indira Banerjee's Tufan Singh. This is subsequent judgment, Lordship. Her Lordship was not following this decision. He was already in dissenting opinion in Tufan Singh. Tufan Singh is 3 judgments decision. And 3 judgments decision already held that this section 67 statement before the co-accused is not admissible. Now the latest position is in case of 438, it is admissible. Because the chance has to be given for interrogation.
In Tufan Singh
and Lordship,
our investigation has been completed.
Yes, my lord. Lordship, investigation in this case
completed. My charge sheet submitted. My charge sheet submitted. I have full instruction.
Lordship, charge sheet submitted, but the case that he says the CDRs, the connection, continuous connection with the arrested accused person and this person prior to the arrest is there. The connections. So Nawaz Khan is there.
3 judge bench is Tufan Singh. Thereafter, all are not.
Nawaz Khan,
And
Supreme Court
Justice
judgment.
Banerjee
CDR here also
dissenting
CDR
opinion
corrections are
at
there.
that time also, my lord. Charge sheet submitted,
Para
one
4,
of the,
para 8, para
one of the co-accused already.
Next circuit which?
Next circuit, Mr.
Lordship.
It needs consideration.
Lordship.
Yes, my lord.
Item number 40.
I'm for the petition. That's Lordship.
Judgment.
Judgment will put it.
Allegations under section 498A and 304B. I'm standing for father-in-law, petitioner number 1, and mother-in-law, petitioner number 2.
It is caused by poisoning, my lord. The 161 are there, general allegations. Husband, my lord, husband is on bail.
Issue.
Charge sheet submitted.
Charge sheet submitted.
Charge sheet, my lord,
Submitted.
pending, my lord, according to my. report.
Pending.
Submitted.
The allegations are under sections 498, capital A oblique 304, capital B,
304B.
IPC. Stop.
Please hand over the charge.
The petitioners are the father-in-law and the mother-in-law of the victim lady. Stop. They say that they have been falsely implicated. Stop. There are no such implicated. Stop. Paragraph. We have heard learned counsel for the state who opposes the prayer for anticipatory bail. Stop. We have seen the material in the case diary, including statements of the victim lady as well as other persons. Stop. The allegations against the present petitioners are general and omnibus in nature. Stop. Charge sheet has
Not filed.
not filed.
Not filed, my lord.
Paragraph. Considering the
Bollam.
nature and gravity of the allegations and the possible extent of complicity of the petitioners in the alleged offense, we are of the view that immediate custodial interrogation of the petitioners may not be necessary so long as they cooperate with the investigating officer. Paragraph accordingly.
May I?
Charge sheet
This is,
submitted.
No, not filed, not filed, not filed.
this is
Suicide.
suicide. Suicide.
Two registers you'll have.
There is no suicide note by the
That's all, that's all. 10,000 with 2 days.
We have granted your prayer.
Arresting officer, 432 compliance to meet the investigating officer of this case. As been called for till submission in final form.
line.
41.
Lordship, I am for the petitioner. Lordship, allegation under section 498, 328, 34 of IPC, Lordship. Lordship, the matter has been amicably settled between the parties and the wife presently residing at her husband's house.
No medical report is there, but only burial ticket is there, my lord. Section 328 properly not attracted in this case, my lord. And this petition is the principal accused. Charge sheet submitted.
Why 328 has been started?
As per the allegation of the de facto complainant in the FIR, my lord, all the in-laws try to poisoning her.
Other co-accused person granted bail, Lordship, and if
No.
this
As per
petitioner granted bail, there was
FIR person.
no problem, Lordship, from the part of the complainant, Lordship.
Insertion of poison is there.
No, my lord.
Allegation.
Allegation is
161.
there. Allegation is there. 161 is of the neighbors of the relatives of the de facto. Charge sheet submitted.
No, in medical charge sheet submitted.
Yes.
বলে দিন।
Issue. The allegations are under sections 498 capital A oblique 328 oblique 34 IPC. Paragraph. The petitioner says that the allegations are totally false. Stop. He has no role in the alleged offense. Stop. Paragraph. We have seen the material in the case diary. Stop. We do not find prima facie, any material to support the charge of administration of poison. আছে? রয়েছে? ও, আচ্ছা, ছেড়ে দাও।
161 আছে।
আচ্ছা, তাহলে prima facie, we do not find any material in the case diary which would justify the rejection of the prayer of the petitioner. Stop accordingly.
Especially when investigation has been.
Especially when charge sheet has been submitted after completion of investigation.
10,000 with 2 registration like amount. Satisfaction ACGM Dinhata. For 38 to compliance. Appearance before the learned ACGM Dinhata within 21 days.
Grateful Lordship.
Grateful.
42, my lord, I'm for the petitioner. My lord, in this case, total 5 accused person, my lord. 4 are already in bail.
What's the nature of the offense?
My lord,
302, my
section 302 and 34, my lord. And I have, my lord, your petitioner, I have no role in this case, my lord. Charge sheet have been submitted.
He is named in the FIR.
Yes. And all the 161 statement, the name is there.
No eyewitness.
Eyewitness is there.
Eyewitness name.
Then go and surrender.
My lord, all accused persons are granting bail, my lord.
Be that as it may. You will also get, maybe you will also get bail.
Page
My lord,
5, 9, 10, 13.
What is
25,
what are the injury reports?
72,
What are the
75.
PM,
my
PM
lord. 75. Sorry, my lord. 51.
$55.
51, my lord. This petition on name reflects 5, 9, 10, 13,
What do you do?
25.
and my lord, in the charge sheet, last line, my lord, kindly see.
Charge sheet is there, but we are not
My lord,
inclined.
investigation officer paid for
Sir,
the
we are
serial
not
number.
inclined.
Either we reject or you not press.
My lord, not press it. Grateful.
43.
I'm for the state.
My lord, 498-302, 3 accused are on bail. I have annexed the orders.
Who are you?
I'm the
Husband of the
husband.
deceased.
Is absconding.
Go and surrender them.
No, who are in custody to sister-in-law and
He
the
is the
parents.
main assailant.
Yes, yes.
No, no,
He's
no,
the
no.
prince. He's the accused.
He's
He is
the
the main assailant.
Yes, yes.
No.
Death occurred on account of.
My lord.
Injuries, antemortem in nature.
May
The case diary, my lord.
I submit one thing? In the order, on the, it has been stated that 164 statement, it has been stated the brother-in-law, one of the brother-in-law is the main assailant, and on that ground, the first bail was granted. This is clearly
But the
stated in the
bail-
order. I have annexed the order. Because he has no role.
The co-accused
He has
person,
no role.
Obtain regular bail.
It has been clearly stated that the recorded under it appears that the principal accused, namely brother-in-law of the deceased, is in custody. The husband of the deceased is absconding. The statement of one of the brother of the deceased prima facie does not implicate the petitioners. But the brother of the deceased has stated
his
that
son, his son has given
one
164.
brother-in-law who is insane, he has done this.
Why is the 164?
My lord, page number 48. The relevant portion.
48.
Yes, my lord.
Petitioner's son.
Petitioner's son.
How old is he, the son?
Lord,
He is about 7 years.
that I will check.
There must not be.
What is the name of your client?
Devashish Pal.
Then who is Kanupal?
Kanupal has been granted bail by your honor.
Negotiation power.
3 days back.
Lord,
This is statement of whom?
Lord, son of the present petitioner. His mother has died.
There is There is another 164 statement, my lord, by one Taposh Pal, the neighbor. Actually, one brother-in-law, he is insane, he has done this thing. The first bail order term is clearly stated.
How many persons have been assaulted?
Huh?
My lord, totals, five.
Huh?
Five, my lord.
Accused person?
Yes. Kanupal, Tapushpal.
No, one Tapospal has also been assaulted.
Yes, Taposh Pal is in custody.
Tapushpal is in custody. His bail prayer has been refused by your lordship.
বুঝতেই পারছি না এটা। What is the FIR?
If Your Honor kindly goes to the
First, my lord, page number 1.
There is not one at the bottom. Oh, just want to দেখলে কিন্তু দাঁড়ান তো।
charge sheet has been filed, Your Honor. My lord.
Let us just a minute. Tapospal is a neighbor who went to rescue the lady. He was also assaulted.
Yes. Neighbor was also assaulted.
There's two Taposh Pal, in fact. Brother-in-law is also Taposh Pal and one.
Where are the 164?
My lord, page number 48.
Page number 48.
Yes.
So 48 is the page now. If I 164 of whom?
One son, my lord, Biraj Pal.
Page number 48, no, 46, 47, 48. No, it was hard by us, no?
This petitioner is no way involved, my lord. Choto Kaka, that is the brother-in-law, he is the main. He is insane person, yes.
Another is another one here, no? Investigation completed.
Yes, Judge.
He is what? He's the brother-in-law.
He's the husband.
Husband. The allegations are under sections 498A, 341, 325, 307, 302, 34 IPC. So the petitioner is the husband of the deceased lady. Paragraph. The petitioner says that he has no role to play in the alleged incident. Stop. The main assailant was another person, another of the family members. Stop. He says that Yachi submitted. He says that he is prepared to fully cooperate with the police personnel. Paragraph. We have seen the material in the case diary, including statements of witnesses. Stop. In particular, we have seen the statement of the petitioner's son.
And a neighbor.
And that of a neighbor. Stop. There is nothing specific against the present petitioner. Stop. Paragraph. In view of the aforesaid, and also keeping in mind that charge sheet has been submitted following completion of investigation, we are of the view that The petitioner need not be taken into custody immediately, paragraph accordingly.
In the event of his arrest, 10,000 with 2 registers your like amount, satisfaction ACGM Siliguri, 430 to compliance, to appear before the learned trial court within 21 days.
But I have for the petition. Offense under section 341, 443, 325, 326, 307, 427, 596, 34, 120 of the Indian Penal Code. But these are show motor complaint, my lord, fight between two group of.
State.
State, Passover. Passover. Forty-five Passover.
Well, I am for the petition.
Do you know? Are you aware of the fact? Passover.
Madam, I'm appearing for the petition.
You are for the state.
Let the briefs be handed over to you.
Tell us.
Well, it kindly comes to annexure P1 at page 9. It's that case where the Kuwaiti case and the husband of the deceased has been implicated as an accused. Charge sheet submitted.
Page?
Page 9, annexure P1. The order of this honorable court passed by your lordships.
Who is the present petitioner?
He is the husband of the deceased. If I was registered against unknown persons, even I was injured. I have been treated in the hospital. And I'm in custody since 18th of January 2022. Charges have been framed. 3 of the witnesses have been examined. They have turned hostile. I'm not sure, but remember last week. That
What is his involvement?
My lord, he is the husband of the deceased, my lord. Circumstantial evidences is there, my lord. There are several 161.
Oh, there's a illicit relationship with another lady, no?
A matter of Dokaiti is involved in this case, my lord. Charge sheet submitted. Out of 30 witnesses, 5 witnesses already examined, my lord.
And they have turned hostile. My father is the de facto complainant.
Raila Sultana was enlarged on bail.
My lord, my lord,
Footing is same almost.
Yes.
I am in better footing. I was injured. I have been rescued by the local peoples and been taken to the hospital. No eyewitness.
You have been injured.
My lord. My wife has been killed and I was injured. Have thrown.
Then how you have been implicated as an accused?
Lordship.
As per the FIR, my lord. FIR name.
It's an unknown FIR, he told.
Yes, Lordship, it is unknown.
Then how he has been implicated?
Subsequently, they got the information from the Lordship will find from the FIR. It's unknown, miscreants.
Unknown miscreants, my lord.
Then how he has been implicated? That we intend to see.
Don't have the copies of.
What is the name of your client?
Well,
Ekramul Haq.
Ekramul তার বইয়ের না হাত ধরেছে এবারে আমি চাকু বের মজিদার গলাটা একটা টেনে দিই।
As per FIR, ছেলে and ছেলে বউ গুরুতর আহত হয়।
আসুন। Heard learned advocate for the petitioner, learned advocate for the state. Stop para. At the very outset, learned advocate for the accused petitioner draws attention of this court to the photocopy of the order dated 6/7/2023 as passed in CRM within bracket DB 353 of 2023, whereby and whereunder one co-accused was enlarged on bail by this court. It is contended that considering the fact that the present accused petitioner is similarly circumstanced with the said charge-sheeted accused person, with the said charge-sheeted accused person already enlarged on bail, the instant application for anticipatory bail may be, it is also a bail.
Bail.
It is bail may be considered favorable. Stop. Learned advocate for the state opposes the prayer. Stop. On perusal of the entire materials of this CD, we are convinced that the present accused petitioner is similarly circumstanced with the accused already enlarged on bail in connection with the aforementioned case. Accordingly, এটা সেম হবে, খালি নামটা চেঞ্জ হয়ে যাবে, খালি নামটা চেঞ্জ হয়ে যাবে, বাকি সব কন্ডিশন আলাদা আলাদা থাকবে।
Your Lordship, I am for the petitioner. Your Lordship, I am not the petitioner is not the FINM accused. He has been called under section 160 notice and has been arrested after 1 month of the incident. Your Lordship, the incident happened on 23/4/2023 and the petitioner has been arrested on 23/5/2023.
My lord, present, may I? The present petitioner is a ex-boyfriend of the victim lady, my lord. And after 2 days, the dead body has been recovered on the railway track. It is in the very rust condition, and head was totally crushed. And my lord, CDR, all the CDR is corroborating with the prosecution case, my lord. And my lord, page 75, kindly peruse. This is a PM report. There's a total indication is there. Death is due to the strangulation. It's homicidal indication.
May I, Your Lordship?
So he's the only accused.
No,
Your Lordship,
Samrat Sarkar is another accused. He's a present boyfriend. And the present petitioner is a ex-boyfriend of the victim girl.
Your Lordship, may I, Your Lordship? Your Lordship, I am not the FINM accused. Kindly see, Your Lordship, the forwarding report.
Circumstantial.
Investigation is well through, my lord.
Your Lordship, there is,
Investigation
And
is
at the time of
Investigation is not complete.
No, not complete. My lord. At the time of the death, my lord, she was pregnant. So, my lord,
please, please.
Your Lordship,
And
kindly
safe is a
see the
report is yet
FIR.
to be
Your
done.
Lordship, kindly go to see the FIR. The allegation is only against the
Wait for some
accused
time,
person.
let the investigation
Your
be
Lordship,
complete.
then allow me to not press this
Yes.
application.
grateful, my lord, grateful.
Not please.
Grateful, Your Lordship.
48.
I am for the petitioner, Lordship. Lordship, the petitioner is in custody nearly 3 years, Lordship. As you kindly see, the
Only the
petitioner-
detention,
Lordship,
only the detention.
no, not detention, Lordship. Kindly see column 10 of the memo of arrest, Lordship.
Where is that?
In the column memo of arrest. Can you see the?
You have not annexed.
No,
Unless you have annexed, how can we see?
no, there is a CD. Charge sheet has been submitted, Lordship. See the thing?
Column 10.
Column 10, there is one Mahesh Burman.
Then
One Mahesh Burman was there. He is a police official. There are 2 raiding party witnesses. in
Police
the-
officer.
Yes, his statement has not been.
No,
There is no 161.
Please.
Mohit Osman is there.
No,
Signature
he
there.
is not. His statement is not recorded. He has not been cited as a charge sheeted witness even. Not only that, the entire seizure list was made in presence of.
That is not a.
Kindly see,
that
kindly
is not
see.
a
No,
condition.
what is the scheme of section 40B or 41B? Kindly see.
The scheme of the Lordship, kindly see.
Any other point? Mr.
Any
Shah?
other point? Yes. Section 50 has not been complied with. Kindly see the entire FIR. Kindly see the FIR. May I read out?
Listen, place the matter
Lordship,
before the
this
next
is,
circuit.
the petitioner is in custody for 3 years. Lordship, kindly.
Next circuit, next circuit.
I am
Try your luck. We will not grant you.
Next circuit.
then the same.
Next circuit.
Next item same.
Next matter also same. Very well. 48, 49. Next circuit.
Item number 50.
Lordship, I'm for the petitioner.
সবই NDPS.
Lordship, petitioner is a driver of the Prabhati Courier and Cargo. Lordship, he is in custody for 221 days. Now, Lordship.
Possession from him.
Lordship, he is the driver of the Courier and Cargo, and as per the direction of the consignee, Lordship, kindly see, as per the direction of the
He's the driver. He was carrying, my lord, the contraband article in a vehicle.
He was nabbed.
My lord, parked the
Lordship,
vehicle in front of a Robiul Islam house. Who is the
consignee?
Robiul Islam house, my lord?
Caesar list, Caesar list.
My lord, Caesar
Yes.
list, my lord, is page 7 and 8. my lord.
Lordship, kindly.
He's the driver.
Yes,
my lord.
submit, Lordship.
He was carrying the
You're
contraband article.
listening.
Lordship.
Please submit. Rajesh.
Consignee's owner has already, consignee owner and the man already granted bail by your Lordship. Lordship,
Not
kindly-
inclined.
Lordship,
Not
Yes,
inclined.
kindly come to my,
Not inclined. Do you hear us?
Lordship, kindly come to, he is falsely implicated. Lordship, kindly come to, let me submit little bit, Lordship.
All right, make a submission.
Lordship, kindly come to my petition, page number 15. 15. This is a letter of intent between Sarkar Medical Howrah and BZB's Logistic, which is a brand name of Express Bees. Express Bees with the Express Bees and BZB is the trade name. Now, Lordship, as per this page 15 letter of intent, he is the consigner. This Howrah, Sarkar Medical Howrah is a consigner. He booked. Now, Lordship, kindly come to page number 34. As per the direction of Sarkar Medical Howrah, the transporter BZB received consignment from Blue Zone.
So your ground is that you are not aware.
No, Lordship, I am the driver, and as per the direction of the consignee,
But
I delivered
unfortunately was record from your position.
Lordship,
What can be done?
Lordship, kindly see Caesar list. Kindly see the Caesar list.
আসুন
Lordship.
উনি চাইছেন রিজেকশন একটা আসুন
হ্যাঁ।
নিয়ে নিন।
No, Lordship, kindly.
Yes, we have understood.
Lordship, 1 minute, Lordship.
Ma'am, we are-
Ma'am, we are running out of time.
We have heard you enough. Enough.
House of the
Yes, আসুন
House of the Robin.
on perusal, hard learned, no.
Lordship, no,
This case I will not allow.
After not wasting our time.
Lordship,
No.
Hard learned advocate for the
missing this,
petition,
Lordship,
learned advocate for the
May
State
not
Act
miss
level.
this, Lordship, kindly.
Stop. On perusal of the entire materials of the case diary, it reveals that sufficient materials, commercial quantity of contraband materials were seized from the possession of the
Lordship, petition of-
present
the House
accused
of the
petitioner.
Robin.
We are dictating an order, madam.
Considering the statutory restriction under section 37 of the NDPS Act, we are not inclined to exercise our discretion under section 439 CRPC, IPC Act. The CRPC Act will be start for 439 CRPC in favor of the present accused petitioner, and accordingly prayer for bail is rejected.
Next.
51.
Pass over.
52.
Lordship, next circuit.
52 next circuit.
53.
Next circuit.
54.
Pass over.
54, madam, for next circuit.
Next circuit.
55. Next circuit.
NDP is only just a
56.
56.
I am for the petition.
Next circuit.
No, Lordship.
Okay.
41 be non-compressed, Lordship.
Oh, sir.
Lordships, actually, I have received the CD. A CD is not visible, your Lordships.
Okay,
so far-
eligible. Next,
Lordship,
circuit.
Lordship, 41, your Lordship. I annexed the arrest memo, Lordship.
No, CD is required.
CD is required, CD
Actually,
is
your
eligible.
Lordship,
No, no.
We understand, we understand.
Next set.
it is
Next
very
side.
difficult as because huge quantity of clouds.
Okay.
Lordship,
57. Yes, ma'am. I am for the petition.
57.
I am for the petition.
Who is for the state?
My lord, this is a case under the provisions of NDPS Act. And
I
before
am for the state.
before I waste your lordship's time, my lord, only one point, kindly peruse the memo of arrest.
Page,
That is not in my petition, my lord.
memo of arrest, what is there? What is there according to you?
There is no memo of arrest, my lord.
No, there is something.
There is no memo of arrest,
Sir,
which is the basic necessity of arrest, my lord.
This is the inspection memo, Lordship.
Inspection memo comes after arrest memo, my lord.
I received the CD just half an hour back.
Where is the memo of arrest?
I didn't find it actually.
It is not there, my lord. Charge sheet.
Huh? See, I will
Next time.
appear করতে বলতে হবে।
Next time, next time.
At the very outset, learned advocate for the petitioner submits before this court that the present accused petitioner has been apprehended without executing any memo of arrest. It is your contents.
My lord, my lord.
Stop para. In course of his submission, learned advocate for the state submits before this court that he also could not find.
Yes, Lord. Just now I received the CD and I got the inspection.
Learned advocate for the state submits before this court that though he received the CD only 15 minutes back or half an hour back,
15 minutes.
15 minutes back, he could not find the arrest memo in the CD.
However, inspection memo is there.
However, he found inspection memo in the name of the present accused petitioner. Stop. Such being the position, let the matter be placed on such and such date before the next available circuit bench.
My lord.
Stop.
My lord, meanwhile, I may be released on interim bail, my lord. My lord, this is the basic tenet of the criminal jurisprudence has been violated. my
Remain
lord.
present in person along with the original case diary
Lord.
It is the original.
to explain the discrepancy in the CD if there be any.
Lord.
It may not have been violated. Therefore, we need the original CD.
Lord.
Date টা কবে দিয়ে দেবো?
My lord, since charge sheet has been submitted, my lord. And off the record, my lord, I'm just placing one thing. Since charge sheet has been submitted, my lord, I am aware there is no memo of it. Lordship may peruse in the next circuit.
Take advantage of that.
Grateful, my lord. Grateful. Hey, Janam.
58.
Pass over.
Yes, my lord. I am for the accused petitioner, my lord.
Yes.
This is a very interesting and surprising.
No
NDPS
CD, Lordship.
case.
No CD. Next
No,
circuit.
Next circuit.
59. Lordship, I'm for the petitioner. Lordship,
Who is for the state?
Lordship, since page 20 of my petition, I had many points, but for the scarcity of I am just
Memo of arrest. Memo of arrest.
memo of arrest, signature, my signature is not there in the Caesar list. Memo of arrest, column 10 blank, page 20 of my petition, Lordship. Column 10 blank.
Is it correct? এই একই order হবে।
And Caesar list also, Lordship.
33 সেই যে ছিল।
এই যে page column 10 blank.
Column 10 blank.
Lordship, I had another document that.
Mr.
No,
Ganguly.
yes, Lordship, yes, Lordship, yes, Lordship.
We independent member of the family or respectable member of the locality.
Grateful, Lordship.
Item number 60.
I'm for the column 10.
Column 10. দেখাও
Who is for the state? Column 10 is bank.
My lord, a huge quantity of narcotic, my lord.
We understand column 10 is blank or not?
No, it's blank.
Blank.
Same.
Column 10 you have annexed.
Yes, this is the certified copy.
Mr. Chakraborty, Please tell your officers to do something.
এটা আপনি same order, column 10.
Alarming situation.
Yes.
61.
61, my lord, now for the petition.
61.
Now for the state. My lord, page 20 to 24, my lord. Non-compliance of section 50. They have a printed form, notice served to the accused persons for such and the independent witness. It's a printed form. I have no objection. And the sign is at the, that is a page, signature was taken on the page number 20. 21, signature is taken on the last point in the blank, on a blank page, the signature was taken. Letter is a printed form. I have no objection. Next page, I have no objection. They have printed what their consent doesn't matter. They have police have given a printed form, signature, all the pages on the last point that is taken on the blank page. There's number 2 and all the accused persons. On the blank page, last, and that is one thing. Page number 20, my lord.
What is that? Notice under section 50.
Yes.
What did 50 says?
Notice to the independent witness, Your Honor, to become the A.
Notice to the independent witness,
my lord.
My
It is
lord,
a
these
print-
things are subject of trial, my lord. First
No,
of
no, this is nothing.
regarding
such a-
memo of arrest
No,
and
no, no,
section
no,
10,
no, no.
column 10 has been complied.
No, just.
Independent witnesses are there in the scissor list.
My lord,
Caesar,
Yes, everything is okay.
Caesar list is all right.
This is taken on blank page, page 21. Please come to page.
Argue it at the trial.
Last rejected in the month of February.
You see where the signature was taken on the blank page on the last point, all the pages.
This is a
On
common,
the last point, all the pages,
this is one of
21.
the common ground of the defense, my
No,
lord,
no,
that
no.
signature was taken in
My
the
lord,
blank page.
my lord, to
This is
blank
very
page.
common.
No, it is a printed form. They have.
Sir, we are not sort of hearing.
My lord.
How,
They have-
yeah.
My lord, they have given a printed form. I have no objection. They have taken that. And number two, there is discrepancy in 162. The officer, the gazetted officer himself stated that that is not matching with the FIR. FIR stated every person. It is FIR. It has been stated. FIR. It has been stated from each person seized 7 kg 200. The one officer and the gazetted officer himself stated in 161.
Very well. Admittedly, commercial quantity of contraband item was recovered from the possession of the petitioner.
Then, my lord, may I kindly.
Not press.
Not press, my
Not
No,
press.
my lord.
not press, my lord.
Not press.
No.
Passover matters.
We'll rise at 2 o'clock.
Yes, ma'am. Hey, 45.
44, my lord.
Next circuit.
Very well.
Next circuit.
45.
Petitioner,
45.
Yes.
anticipated bail.
45 you have mentioned.
Anticipatory.
Lordship, there is multiple injury, Lordship.
Multiple.
Lordship, allegation under section 341,
Fracture of
323,
leg.
325, 307, 354, 427, and 506.
Stage of investigation.
Lordship, charge sheet not submitted.
Lordship, this is the long-standing enmity between the de facto and the petitioner.
Injury report is on.
Lordship.
Injury report, page 29 onwards.
Page 28, 29, and 31.
He is named in the FIR.
Named in the affair.
What is his role according to
No
the
role,
FIR?
no role. No role has been attributed.
Paparaj Burman.
161 statement.
Or learned advocate for the petitioner, learned advocate for the state at length. Stop. On perusal of the entire materials of the case diary, it reveals that in the injury report of the victim, the present accused petitioner's name is transferring as the assailant as recorded by the doctor, as recorded by the treating doctor, from the version of the victim. Stop. However, considering the fact that the injuries are not so much serious, and keeping in mind that investigation has been proceeded for a considerable length of time, we're inclined to take a lenient approach. In the event of his arrest, the present accused petitioner may find below rupees 10,000 with 2 registered security like amount, satisfaction arresting officer 432 compliance. Is further directed that the present accused petitioner shall meet the investigating officer of this case as and when called for till submission in final form, and shall not 432 compliance shall not commit any threat, endorsement, and group.
Grateful, Lordship.
Grateful, Lordship.
Item number 51.
Next circuit. That's all.
Oh, two dimensional.
My lord, one revision, my lord. My lord, item number 32, my lord, charge sheet has been submitted. Just kindly recording this submission, my lord. Item number 32.
52.
32, my lord. Mr. Ahmed is on the defense, my lord, on that matter, my lord.
What we have recorded?
There's no change in circumstances. Change in circumstances is there, my lord. Charge sheet is submitted. That's right.
That is not a change in circumstances.
My lord, my lord.
According to us, there is no change of circumstances.
My lord, my lord.
Do we mention why it is there?
Item number 1.
Item number 1, Jagadish Mondal.
Lordship. Lordship, small correction. It would be Siliguri Special Correctional Home instead of Subdivisional Correctional Home.
Let the order dated July 13, 2023 be corrected by substituting
Subdivisional Correctional Home, subdivision only.
Siliguri subdivisional. What should it be?
Special Correctional.
Substituting Siliguri Special Correctional Home.
Special correctional.
Not subdivisional.
No.
Siliguri Special Correctional Home, it of inverted comma, in the place and stead of Siliguri Subdivisional Correctional Home.
Yes.
Stop, it of inverted comma.
Siliguri is a subdivision. Even then, its name is Siliguri Special Correction. No.
Let this correction be incorporated in the order.
This commissioner is here, my lord.
Okay.
Special status.
Next.
Enaur Islam.
My lord, it submitted that it is a additional chief judicial magistrate. It should be
Additional
district and session judge under POXO Act.
It is a 438 or 439.
It is a 438 application, madam.
Is it POXO?
Yes, my lord, it is POXO. Another 4 and 17 of the POXO Act.
Let the order dated July 13, 2023 be corrected by substituting additional
District and session judge.
district and sessions judge.
Under POXO Act, Mathawam.
লিখেছো under POXO Act.
Special court under POXO Act, Mathawam.
Special court under POXO Act.
আমি বলে দিচ্ছি
হ্যাঁ।
additional session judge come special judge within bracket POXO Act Dinhata.
Mathawanga, man.
Oh, sorry, Mathawanga, district Kuchbihar.
District Kuchbihar.
হ্যাঁ, এটা পুরোটা ইনভার্টেড কমায় লেখো, হ্যাঁ, ইন দ্য প্লেস এন্ড স্টেট অফ, আবার ইনভার্ট কমা দাও, অ্যাডিশনাল চিফ জুডিশিয়াল ম্যাজিস্ট্রেট কমা মাথাভাঙা, এটা ইনভার্টেড লেখো। Stop, let this correction be incorporated in the order. Yes.
Last but not the least, Lordship, I am just saying that I am appealing for my behavior and for me.
No,
Lordship,
it's fine.
I'm asking if the item number 50 order can be recalled from the.
No, that cannot be done.
Litigant should completely suffer for.
No, the litigant hasn't suffered for your behavior,
Pass the application.
not for your behavior. That is all then. So much for this circuit. Hope to see you again.
Lordship.
God bless all.
Lordship.